Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 5th, 2024. We have 12 bills on the docket. Yeah, not 20. And we're going to start off with Senator Charles with Senate Bill 662. We'll then move on to 1096, 872, 907, 927, 929, 948, 1036, 107, 894, 1030, and we'll wrap up with Senator Reedy with 1075. So without further delay, Senator Charles with Senate Bill 662.
I want to ask that my distinguished panel come up and join me while I give the testimony. So I ask that Kevin Liles, CEO of 300 Electra, Lucius Outlaw. I'm going to ask that Skyler Johnson, Reverend Kobi Little from NAACP. And then I have 3 additional individuals who will be here remotely, so you guys can have a seat. Eric Nielson from University of Richmond, Mac Phipps, he's remote as well, and Greg Gonzalez, who's also remote. All right, we'll go ahead and get started. Chair Smith, Vice Chair, members of the Judicial Proceedings Committee, for the record, I am Senator Nick Charles. Senate Bill 662, the PACE Act, seeks to protect various forms of artistic expression from being used improperly as evidence in a criminal procedure. There is prevailing national and local trend involving the use of creative expression, notably lyrics, as courtroom evidence. This trend is not only concerning due to its potential for misinterpretation, but also because it often perpetuates racial bias within the justice system. Research and anecdotal evidence suggests that interpretation of creative expression be heavily influenced by racial stereotypes and prejudice. As a result, individuals from marginalized communities, particularly Black and Brown individuals, may face lopsided scrutiny and harsher judgments based on their artistic output. You will hear today from legal and music experts as to how the creative expression evidence often leads to the unfortunate reality. Senate Bill 662 will not eliminate all circumstances where creative expression can be used in criminal proceedings. However, it will establish a reasonable threshold the state must meet to be able to use and introduce this creative expression as evidence. Moreover, by setting clear criteria for the admissibility of creative expression as evidence, the bill ensures that legal proceedings are guided by objective standards rather than subjective interpretations. If the expression goes too far and can be considered a confession or can provide critical information to hold someone accountable for a crime, this law will still allow the state to pursue that evidence. Senate Bill 662 simply seeks to limit the admissibility of creative expression as evidence by providing that it cannot be used against defendants unless the court finds that the defendant intended the creative expression to be literal, the creative expression refers to the specific facts of the alleged offense, the creative expression is relevant to the disputed issue of fact, and the creative expression has probative value that cannot be provided by other admissible evidence. California was the first state to enact legislation of this kind in 2022, and Louisiana followed suit in 2023. New York, Missouri, Georgia, and a few other states have proposed and passed similar legislation. Congress has also introduced similar legislation in the past 2 years to address this issue. Maryland can now take the lead on this issue. We can be the first state on the East Coast to take this law to the finish line and ensure that creative expression is not improperly used as criminal evidence. We have led in police reform, juvenile justice reform, and most recently prison reform. Let's lead in this too. For these reasons, I urge a favorable report on Senate Bill 662. And as I stated, Mr. Chair, I have a distinguished panel. Who I'll go to allow to speak first is Kevin Liles, who is a well-renowned music executive. He has touched so many lives through his music through the years, and you have seen him in a case most frequently on the news that is getting a lot of national attention with the Young Thug trial. And he has been a mentor to so many within the music industry. And so he can speak from a realistic standing. So I'm going to open it up to Kevin to give his testimony, and then we'll open it up to Lucius Outlaw, and then to you, Kobi Little, Reverend Little, and then Skyler Johnson. And then we'll go to our folks online.
Excellent. Thank you very much, Senator. And Mr. Liles, if you could come to the podium to testify, that'd be great. Thank you very much.
Good morning, Chairman Smith, Vice Chairman Wall Striker, members of the Judicial Proceedings Committee. My name is Kevin Liles, and for those of you who don't know me, I'm just going to provide you a little bit of background because I'm home. I was born in the west side of Baltimore in 1968, and many of you know what that means growing up in Baltimore. At 16, I could be in jail, locked up, or dead. I went to Rosemont Elementary School. I went to Woodlawn High School. Went to Morgan State on an electrical engineering scholarship. And yes, at 16, I was an artist. And then I went from intern to president of Def Jam Records, all before the age of 30. That was over 25 years ago. And I continue to be of service through music. I've also like to know that I give back to Maryland. I built a stadium in Woodlawn. I raised $254 million for the Centennial Raise at Morgan State. I'm the lead curator at Preakness Live, and I've hosted amounts of philanthropic efforts throughout the city. But I'm also an advocate for law enforcement and public safety. When the Freddie Gray arrest happened, Camelo and I walked the streets of Baltimore to quell our city. For the past 3 years, I worked with the FBI at the highest level to engage HBCUs all around the country to give more credibility in the African-American space. We've dramatically increased HBCU applicants in the FBI. We also had 100 HBCU presidents come down and actually talk more about how we can have a better pathway to higher law enforcement. Now, most of you think when you're successful, you come and you want a tax break or you want something done, but I'm here to protect our culture and save lives. I'm here to protect kids like me who were born with a rusted spoon in their mouth. I'm here to stand up for the PACE Act and say, please join me in saving another kid's life. The number of speakers here today, they would detail their own arguments, but I have to speak for myself because make no mistake about it, I'm here to save lives. And the last thing that I'll say, because I know this time is up, I know there's a juvenile justice bill making its way through the chambers. PACE is part of that solution for young people. When you've got kids with nothing but dreams and hopes, but only bad options, you get those things. If you criminalize their therapy, you're going to stop them from making art. I ask that you not do that. I ask that you join me. I'm asking you to save another life like you guys were able to save mine. Thank you.
Appreciate it. Thank you very much, Mr. Liles. Whoever else would like to come on up?
May I proceed, Chairman? Thank you, Chairman and members of the committee. My name is Lucius Outlaw. I'm an associate professor at Howard University School of Law, where I teach criminal law courses. Prior to Howard Law, I practiced as an assistant federal public defender in Maryland for over 8 years. I'm testifying today in support of Maryland House Bill 1429. My testimony supports the bill by addressing and rebutting two objections that are commonly raised by those opposing the bill. That is, first, a common objection is that HB 429 will prevent prosecutors from using valuable evidence to prosecute criminal cases. This is simply not true. It is plain and undisputable that 1429 contains no blanket prohibition barring the evidentiary use of rap lyrics or any artistic expression. The bill's prohibition is limited and narrow. The bill bars the evidentiary use of artistic expression only when the government cannot sufficiently demonstrate that the artistic expression is directly relevant to and probative of the facts and issues of a defendant's case. This is far from a blanket prohibition. Second, a common objection is that 1429 is not needed because Maryland's rules of evidence already provide sufficient protections against the admission of irrelevant and prejudicial evidence. This argument too misses the mark. First, Maryland's rules of evidence sets a very low bar for relevancy and does not adequately account for the inherent inflammatory and divisive nature of rap lyrics. Second, Maryland's rules of evidence are full of what seems to be duplicative rules governing the admission of evidence that clears the low relevancy bar set by those same rules. There's rules about when and how habit evidence can be introduced and expert evidence. HB 1429 recognizes that artistic expression, especially rap expression, is peculiar enough to warrant added evidentiary guidance and protections. Thank you for your time and consideration. I'm open to any questions the committee may have.
Excellent. Thank you. We're going to take questions at the end of the panel. Thank you very much.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, Senators. I am the Reverend Kobi Little. I'm president of the Maryland NAACP. We're grateful that Senator Nick Charles has brought this legislation, and we'll start by urging a favorable report on this bill. Our concerns are probably, our most important concerns are probably threefold, and you should have in your packets our written testimony filed by our executive director, Attorney Nashona Kess. One, we are here in the name of justice. We think that this bill helps to promote justice over convictions. And in this day and age, we need a judicial system, prosecutors, judges, who are more concerned with justice than they are concerned with convictions. And we believe that this legislation helps to get us closer to the administration of justice rather than using irrelevant material to secure a conviction. The second point that we want to raise is the importance of this legislation as it relates to artistic production and creativity. We can't be in a place where the law stifles creative expression. It is through creative expression that we grow our democracy. And for many of the people that I represent, creativity is a pathway, the arts are a pathway to freedom and economic security. And then finally, we'd like to highlight the constitutional issues that we believe this law helps to uphold. And that very simply is the freedom, the constitutional right to freedom of speech and freedom of expression as a form of freedom of speech. And we think, as I have said again and again and again, the Maryland General Assembly has an opportunity to use its powers to strengthen and to promote democracy by upholding constitutional privileges. So my time has expired. We give thanks to this committee for your attentive ear, and we urge a favorable report. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Skyler Johnson. I am a student attorney in the University of Maryland Carey Law Criminal Defense Clinic, here to testify in support of Senate Bill 662. I will focus my time on two important reasons to support this bill, which will bring the rules of evidence in line with the First Amendment and address the disproportionate impact the admission of creative expression evidence has on people of color, especially Black men. First, SB 662 furthers the purpose of the rules of evidence. Maryland Rule 5-102 explains that one of the purposes of the rules of evidence is to promote justice and fairness. However, expert research has indicated that the rules don't always serve their intended purpose when it comes to certain types of expression. Introducing a creative work that is not autobiographical or factual against a person as though it is literal truth is not just or fair. SB 662 strikes an important balance by allowing admission of incriminating statements when demonstrated to be truthful, but screening out fiction. Second, SB 662 ensures evidence is relevant. As the committee may know, relevance is the cornerstone of evidence law. SB 662 provides much needed guidance for evaluating creative expression evidence by requiring additional considerations about the underlying meaning and intentions of a given creative work. It makes sure that the work is actually relevant before it is admitted as evidence and put in front of a jury. This is important because without context, a jury may assume a given creative work is meant to be literal or factual, even if it was entirely fictional. This requires defendants to try it and provide context in their case, which can be costly and difficult, especially for those with limited resources. SB 662 fills an important gap in the rules of evidence. The bill adds a tool to the judiciary's tool belt to ensure due process. In conclusion, SB 662 formalizes and guarantees a process to ensure relevance and promote justice, and the Criminal Defense Clinic strongly voices our support. Thank you.
Thank you very much. Senator, we'll take your virtual witnesses first on this panel, and then we'll open it up to questions. Is that?
Yes.
All right, excellent.
So I'm gonna ask that Eric Nielson.
Mr. Nielson, you're up.
Yep. Can you hear me okay?
We can. Welcome.
Okay, thank you. Mr. Chairman and members of the committee, my name is Eric Nielson, and I'm a professor at the University of Richmond and co-author of the book Rap on Trial. I'm here to express my strong support for this bill. If signed into law, it would provide long overdue protections for creative expression, particularly rap music, which has been targeted and punished by the criminal justice system for decades. Reform is urgently needed. In courtrooms in Maryland and across the country, prosecutors are increasingly introducing rap lyrics as evidence of criminal proceedings. Rather than acknowledge rap music as a form of artistic expression, police and prosecutors argue that the lyrics should be interpreted literally, even though the genre is rooted in a long tradition of storytelling that privileges figurative language, is steeped in hyperbole, and employs all of the same poetic devices we find in more traditional works of poetry. This tactic effectively denies rap music the status of art and in the process gives prosecutors a dangerous advantage in the courtroom. By presenting rap lyrics as rhymed confessions of illegal behavior, they are often able to obtain convictions even when other evidence may be lacking. No other fictional form, musical or otherwise, is misused this way in the courts, and it should come as no surprise that the overwhelming majority of artists in these cases are young Black and Latino men. Our research has identified close to 700 cases where rap music has been used as evidence, but we know the number is far higher and growing, with no sign of slowing without the kind of legal intervention proposed in this bill. And research has demonstrated that rap music has the potential to be highly prejudicial. In one study, for example, divided subjects into two groups and provided them with an identical set of violent lyrics. One group was told they were rap lyrics. The other group was told they were country lyrics. The participants who believed the lyrics came from rap music found them more threatening and in need of regulation than the exact same lyrics characterized as country. As this and other studies suggest, weaponizing rap music against its creators is racially and culturally discriminatory. It is also an affront to the First Amendment protections that everyone in this country should be entitled to. I strongly urge you to pass this legislation and help ensure it becomes the law in Maryland. Thank you, and I welcome any questions you might have after this. Thank you.
Excellent. Thank you very much. All right.
When I ask that Matt Phipps.
Mr. Phipps, you're up. Welcome. Let's take you off of mute. Oh, there we go.
You can hear me?
We can, yes. Welcome.
All right, how you doing? Good afternoon. My name is McKinley Phipps, and I live here in New Orleans, but I wanted to share my story about why I think the PACE Act is so necessary. I come from a family of musicians in New Orleans, and as a young man in the 1990s, I was signed to No Limit Records, which was the most famous label in the South at the time. At a performance one night, there was a shooting, and a young man lost his life. Hours later, I was arrested at my home and charged with second-degree murder. Previously, my criminal record only consisted of a few parking tickets. 10 days later, the actual shooter felt so much guilt that he showed up to the police station with his pastor and confessed, but the police sent him home saying that witnesses had already pointed me out as the shooter. I was not granted a bond during my trial. When the trial came, the prosecutor's first words in his opening statements were my song lyrics. Specifically, he combined lyrics from two songs to read like one statement. He also changed words from third person to first person so that it read like a confession. Some of the lyrics were even about my father's experience in Vietnam. There was no weapon, and all he had was my music and a witness. I was convicted of manslaughter and sentenced to 30 years, A few years later, a district attorney and the sheriff were both convicted of corruption and a string of other crimes. The witnesses who then named me recanted their statements, saying that they were threatened by the investigators to name me as the shooter, And despite all of this, I spent 21 years in prison, and in 2021, the then governor of Louisiana granted me clemency. Since then, I've worked with community organizations, helping young people find hope through music. In closing, what I'm asking you to reflect on today is not the 7,700 days that I spent in prison for a crime that I did not commit, but rather the 7,700 nights my mother and father spent trying to sleep while they knew that their son was in prison. This is what sits on my heart, and I can never give that time back. So with all the information you hear today, please remember that behind each wrongful conviction is a man or a woman like me, who people love and who have people that they love. Thank you.
Yes.
All right, next witness is Greg Gonzalez.
All right, Mr. Gonzalez, you're up. Welcome.
Thank you. Thank you, Chair and members of the committee. My name is Greg Gonzalez, and I am Legislative Counsel at the Foundation for Individual Rights and Expression, also known as FIRE, a nonpartisan nonprofit dedicated to protecting free speech rights for all Americans. We strongly support SB 662. Since our nation's founding, artistic expression has enjoyed broad First Amendment protection. Artistic expression is the lifeblood of our society. Artists critique our government and institutions and shed light on the human experience. Consider all the art that we create and consume on a daily basis, including visual art, videos, movies, and music. Consider the chilling effect that you'd face if you thought a prosecutor might use your art against you to seek enhanced sentences, allege associations that you do not have, or seek to show you're of low character. As other witnesses here today have described, that happens all too often. Some may question why people would make music about violence or detail criminal activity they haven't actually engaged in. Several musical artists, including the rapper Killer Mike, Chance the Rapper, Meek Mill, and Fat Joe, signed on to an amicus brief in a case before the Supreme Court of Pennsylvania, answering that very question. They explained, quote, "Like all poets, rappers use figurative language, relying on a full range of literary devices, such as simile and metaphor. Furthermore, rappers famously rely on exaggeration and hyperbole as they craft larger-than-life characters that have entertained and often offended critics for decades." End quote. And I'd like to emphasize that in circumstances that someone actually creates or participates in artistic expression that is clearly linked to a specific crime, there's an open door for prosecutors to include this evidence. This bill still allows prosecutors to keep our communities safe. FIRE urges the committee to support the PACE Act so that artists can create without fear that their art will be taken out of context and misused against them. Thank you.
Excellent. Thank you very much for the panelists. Senator? Oh, all right. Excellent. So we have a couple questions from, excellent. We have a couple questions from the committee. We'll start off with Senator Carter, Senator Sidnor, and then Senator West.
Thanks, Mr. Chair. Thank you for bringing the bill, Senator Charles. My questions are really, I think, best suited toward the attorney, Mr. Outlaw. Mr. Outlaw, could you come up to the podium? Could you give us an idea in Maryland how prevalent this is? Or I know it's based on the testimony, it's a growing thing throughout the country, but in Maryland cases, how often has this been raised, and how frequently does the relevancy test fail, the current relevancy test?
Well, to your first question, I'm not particularly sure of the tracking numbers. Mr. Nielson probably has a better idea of the actual numbers in Maryland. I do know from experience, it is a practice that is growing. When I was a federal public defender for 8 years, I saw it increasingly, the use of lyrics and artistic expression growing in the later years. And in tracking this issue, the past couple of years, I've seen it grow in Maryland and other places as well. And I especially am concerned as communities are facing crime issues and there's pressure to do something about crime, that this will be a practice that even grows even more in Maryland and other places. And when it comes to relevancy, the fact of the matter is that the relevancy bar set by the Maryland Rules of Evidence is a low bar. And that's not just me saying it, that is the Court of Appeals. In a key case in this issue, Montague versus the state of Maryland, which is a 2020 case. In that case, it was a murder trial where the defendant was in pretrial detention. And while in pretrial detention, he got on the phone that was recorded and performed a rap song that he wrote. And the government sought to introduce that as evidence in his trial. The trial court allowed it. He was convicted, and that issue went up on appeal. And on the Court of Appeals, they affirmed the trial court's decision to allow that evidence to go in. But in doing so, the court set two key points that I think are very relevant and important for this legislation and your consideration. The first is that rap lyrics are inherently prejudicial. And just to quote the court said, "It is undeniable that prior decisions demonstrate the inherent risk of unfair prejudice that accompanies admitting a defendant's rap lyrics as substantive evidence of their guilt. No matter how easily the state may meet the low relevancy threshold when offering a defendant's rap lyrics as evidence, the admission of a defendant's inflammatory rap lyrics risk posing the jury against the defendant." And so the Court of Appeals said, look, the bar is low. That is not enough. The second important point was that the inherent prejudicial effect of rap lyrics can be outweighed by their probative value of their lyrics and therefore admissible when the rap lyrics, quote, bear a close nexus to the details of the alleged crime, unquote. So 662, and I apologize for referencing the companion bill earlier, 1429, but 662 just merely codifies and formalizes what the Court of Appeals acknowledged in Montague, that the guardrails are needed for the introduction of rap evidence or any artistic evidence, given the inherently prejudicial nature of such evidence and the low relevancy bar. I hope
Thank
that
you.
answers your question.
It does. I'm gonna have to go back and read the case though, but because that was my other question that you already answered to some extent, which was once it passes relevancy, what about the inquiry as to the prejudicial value versus the probative value? But in that opinion, according to what you just testified to, the court said that it was inherently
that rap lyrics are inherently prejudicial, but that prejudice can be outweighed by the probative value, meaning it should come in when the lyrics actually have a close nexus to the case, where the lyrics are actually talking about the crime that has been alleged, the conduct that has been alleged, and it's not just an expression of any criminality or any antisocial behavior or any behavior people might find disturbing, that for the lyrics to be admissible, they actually have to be connected to the actual crime. Do they describe the crime? Do they describe the motivations for the crime? Do they describe the victims or the manner of the crime? Those are the things that meet the test, the probative value test, to get over the prejudice that is inherent in rap lyrics.
Thank you. And I don't want to dominate the conversation, but I'm curious. I have a lot more questions I could ask, but I'm also curious about the difference between the trial posture and the sentencing posture of a case, because it's my understanding that this information can be used at sentencing much more easily than it can in a trial for a defendant. Have you had that experience?
Well, in sentencing, a sentencing court has way more latitude in what it can take in to consider to imposing a sentence, meaning a defendant's history, their characteristics, their criminal history, many other things. And so while they might take in the lyrics, I would say there should be, I mean, I don't think this bill addresses that, but personally, there should be limits there, because we don't want to sentence people to longer prison terms because they may make music that other people find objectionable. And so I think there is a danger there, but we don't even get there if the lyrics aren't allowed to be used in trial. And so I think 662 really does address the issue of tying lyrics that the Maryland Court of Appeals have already said are inherently inflammatory, to say, look, you can get over that hump. All you have to do is show that it's relevant to the actual issues of the case. And if you don't want to do that, if you object to that test, my concern is, well, then that is an admission that you want to introduce those lyrics for some other purpose. And that could be appeal to people's prejudices, appeals to people's objection to rap music, which has no place in a criminal trial.
Thank you.
Thank you very much. Mr. Outlaw, would you mind coming back?
I have a feeling you're gonna get
No problem.
So Howard County, well, I'm looking at witnesses that have signed up to speak on today's legislation, and while I do not see, and you can correct me if I'm wrong, I don't see the Maryland State's Attorneys Association, but I do see at least two county state's attorneys' offices, Baltimore County being one, but the other being Howard County State's Attorney's Office. And it's their testimony that caught my attention, and I wanted to get your feedback. Howard County writes, by attempting to codify criteria that have already been effectively addressed by the courts, this bill risks introducing unnecessary complexity and confusion into our legal framework. How would you respond to that?
My response is, I believe they're referring to Montague, that because the appellate court has already ruled on this, that we don't need the 662. My response to that is precedent is much easier to change than codified law. We've seen in recent history, things that we thought were well-settled law are now changed. It's much easier to change precedent than it is to change a codified law. That's one. The other thing is that when it's just precedent and not codified law, then it's not applied uniformly. And what I mean is, when it's precedent, a court can say, yes, there is precedent, but this case is different because of these facts. This little fact over here means I don't have to apply that precedent because the facts aren't exactly aligned in both cases. When a law is codified, a court can't do that. And so my response to that is, what is the danger? What is the fear among prosecutors of having a standard that just says, if you want to use a piece of evidence, you have to show that it's relevant? And relevant meaning that it actually is tied to the issues and facts of the particular case. What is the fear of that? And if the answer is simply it's too complicated, courts deal with complicated issues every day. This is not something new. All we're asking is that the laws say that if you want to use a piece of evidence, show us how it's actually directly tied to the case. If you have a problem with that, please explain why.
So Baltimore County State's Attorney, he focuses on social media and says that he says that Maryland courts have begun to address the standards necessary to authenticate social media evidence. From reading this testimony, I would assume is government going online to get this material that they then use in their trials? I mean, I guess I'm having a hard time of understanding why he's talking about talking about Snapchat and Facebook. How are they coming across this information?
Well, social media mining for evidence is nothing new.
Right.
Prosecutors have been doing that for a long time. And where I think that interacts with 662 is just to say, if that social media evidence that you want to use is artistic expression, you have to meet this standard. Now, this would not bar, if somebody went on Instagram Live and said, I just robbed the bank, look at my money, 662 would not bar the use of that social media post as evidence. This is simply about providing a standard for courts to use when artistic expression is trying to be used as evidence.
And it's my understanding that what the bill is attempting to codify is what the courts are already using. Is that incorrect or is that correct?
That is very correct. It's codifying basically the standard that Montague puts forward, but really the points underneath what Montague says, that rap lyrics are inherently prejudicial, but that prejudice can be overcome if the government shows that the lyrics have a direct nexus to the details of the alleged crime.
Thank you. The next question is, and I don't know if Mr. Liles or Mr. Nielson may be able to respond to this, but who's being prosecuted? Is it the writers? Is it the rappers? I mean, who is it that ended up being defendants?
I'll start and then Eric, you can jump in. The funny thing about music is you have ghostwriters, you have 5 or 6 people writing records, so you never know in a particular case. But I do have to say that who is being attacked is only our music. Country, I can say some country lyrics to you guys, but they don't get attacked. I can read a Stephen King novel, they don't get attacked. I can take you to the opera, and you can tell Shakespeare was a bad boy, but he doesn't get attacked. This is, I don't know the term for it. That's why I got these experts here. But this is about Black and brown people. It's a racist act being in our court systems. And I only just actually, guys, because I live it. I am it. We're 50 years old now. We're growing up. We're pulling our pants up a little bit. We're doing things that that just changing people's lives in our communities. I'm living through a case right now in Atlanta that Stock spoke about, where I have a father of 6 who changed the whole community that's not able to be a father to his children, not able to be a son to his ailing mother, not able to be a leader in his community. So if you ask who it is attacked, it attacks Black and brown people, and it's a racist act.
It's funny that you mention it, because one of the things that came to my mind is, and the lyrics go, "Are you happy? Are you satisfied? How long can you stand the heat? Out of the doorway, the bullets rip to the sound of the beat." Do you know what song that is?
No.
Another One Bites the Dust. That's Queen. So, I mean, that's Freddie Mercury.
All right, well, yeah, listen, we can go toe for toe. Me and her went to a ride, sir, and 10 innocent people died. From town of Lincoln, Nebraska, we all sawed off 410 in my lap through the barren lands of Wyoming. I killed everything in my path. Bruce Springsteen, Nebraska.
Never been prosecuted for
Excuse
those. I said never been prosecuted for those lyrics.
I've never been prosecuted.
Okay.
Johnny Cash. I shot a man in Reno just to watch him die. I shot the sheriff, but I did not shoot the deputy. You go down the list.
I understand. Mr. Nielson, from your research, I mean, who is it that's being prosecuted? I mean, set aside race. That's clear. Are they the writers? Are they the actual performers who are out there?
All of the above. I've probably worked on certainly over 100 cases. I've probably testified either in federal or state court across the country, 15 or 20 times. And it can be somebody's handwritten lyrics, even if they were written years before the alleged crime. It can be the artist who's performing, but not necessarily the person who wrote the lyrics for the artist. It can be the person who wrote the lyrics for the artist. It can be just standing in a rap video next to somebody else who is being accused of a crime that prosecutors will often say this is evidence by association of this person's involvement. So there have even been cases where somebody listening to rap music or writing out the lyrics of their favorite artists, where that has been used as evidence as well. Just listening or copying down your favorite Dr. Dre lyric, and that comes from an actual case. We're seeing it's actually kind of alarming, kind of shocking, the extent to which rap music is being weaponized. But to answer your question briefly, all of the above.
And when did you begin to see this technique being used?
The earliest case we've found is right around 1989, 1990. To answer or to build on previous testimony, yes, we saw a precipitous increase with the rise of social media, right? Because it lowered the barriers to entry for artists, but it also made it much easier for police and prosecutors to mine this content to use as evidence.
And have you, in your research, have you been able to find any other genre outside of hip hop that lyrics have been used in this nature?
The New York Times, in a fairly recent piece, I think it's a couple years old now, went back to 1950. And whereas we've identified approximately 700 cases involving rap music as evidence, the New York Times found exactly 4 examples of non-rap music or fictional expression used that way. 4 over about 75 years. It's worth noting that all of them were either reversed or thrown out eventually.
And do you know which genre of music that was? I'm just out of curiosity.
The case that comes to mind actually wasn't musical. It was somebody's work of fiction. It was, I think it was a detective novel or something like that. This was in Washington State, and that was reversed because it was considered prejudicial. I don't recall off the top of my head what the other genres were.
I appreciate it. Thank y'all very much.
Thank you, Mr. Chair. So, Mr. Outlaw, could I ask you a couple of questions? I'm going to let Senator Charles off the hook. Mr. Outlaw, you've talked about the McCullough decision. I pulled it up and tried to read some of it. It's 38 pages long, so I didn't get the whole thing read during your testimony. And I think you said during your testimony that this bill essentially tries to codify what McCullough said, correct?
I believe it's Montague.
I'm sorry.
That's okay. I understand. I know where you're going.
Right, Montague. And you said that the basic rule is that the state must prove that it's relevant in order to get it in, correct?
Not demonstrate that is relevant, meaning that the lyrics bear a close nexus to the actual facts and details of the charged crime or charged conduct.
Right. From my notes on the Montague case, there was two holdings. The first is the court has to show some sort of temporal nexus between the lyrics and the details of the crime on the one hand. And then secondly, once that threshold is met, the court must establish that the probative value of this evidence is not substantially outweighed by unfair prejudice to the defendant. Would you agree that that's a fair summary of the Montague holding?
I would agree with the second part. I can't completely agree with the first part that there has to be a temporal. I think they found a temporal nexus and they said that was one of the many nexus points. There was a temporal nexus. There was a factual nexus as well. That's why it was okay for the trial court to allow those lyrics in this case.
Okay. So I'm comparing the decision in the Montague case with this bill. And you will agree with me that there are 3 different standards of proof in the courts. The most common is preponderance of the evidence, which means more likely than not. And then there's a second standard, which is a much higher standard, which is clear and convincing evidence, which is frequently used, say, in fraud cases. It's much higher than preponderance of the evidence. And then in criminal cases, it's beyond a reasonable doubt, which is even higher yet, correct?
Yes.
Okay. So in this bill, it says in any criminal proceeding or juvenile proceeding, the creative expression is not admissible against the defendant unless the court finds by clear and convincing evidence that certain things have happened. So you would agree with me, would you not, that this does not use the preponderance of the evidence test. This is a much higher test, clear and convincing evidence in order to get the evidence into admission, correct?
I would agree it's a higher test. I would happily debate how much higher it is.
Clear and convincing than preponderance? Preponderance means
it's a higher
imagine the 2 scales of justice. One scale is a little heavier than the other. That's preponderance of the evidence. I've always thought clear and convincing is the 2 scales are so substantially different. One's much heavier than the other.
I would say it is definitely heavier. What I would say in practice, what is perceived as much higher gets narrow.
Okay.
In practice.
Now, in the Montague case, did you understand the court in that case to apply a clear and convincing standard as to whether or not the evidence in Montague, which the court held was admissible, whether that evidence should have been admitted?
I do not believe so.
So the standard is preponderance of the evidence. It's likely that in Montague, that was the standard the court used, correct?
I do not know that.
Okay. So let's go
At least
on
it's
with
not clear from the opinion.
let's go on with the bill. The bill says you can't get the evidence in unless the court finds by clear and convincing evidence that the defendant or respondent intended the creative expression to be literal rather than figurative and fictional. How in the world would a state's attorney go about proving by clear and convincing evidence someone's intent when someone wrote some lyrics?
Well,
If I were a
was-
state's attorney, how would I try to accomplish that as a condition of getting that evidence into evidence?
I would start by saying that prosecutors are often required to prove somebody's intent,
By
And-
clear and convincing evidence?
or even by reasonable doubt. A lot of criminal statutes require the government to prove somebody's intent beyond a reasonable doubt. It's something they are equipped to do. How would they do it? They would do it by, as in the Montague court, saying, look, the lyrics describe someone shooting somebody with this particular gun in this particular day at this particular time. The facts of the case are that same gun was used to kill the victim in the exact same way at that particular time. And to go to the other point, the clear and convincing standard is something that prosecutors and the courts are very familiar with in the criminal context. The clear and convincing standard is used in the pretrial decision about whether or not someone should be released on or be detained pretrial. It's used in Rule of Evidence 504B about whether other bad acts of a defendant can be introduced as evidence. Is used in Maryland Criminal Procedure Section 8-301, a petition for writ of actual innocence. It's the standard that is used to determine whether or not somebody's petition for actual innocence actually is worthy of a remedy. So the clear and convincing standard is something that the courts and prosecutors confront every day. It is not an impossible burden for them to meet, but something they deal with every day.
All right, so you believe it would be not difficult for a state's attorney to establish by clear and convincing evidence what someone's intent was at the time they wrote a lyric?
Yes, because they do it to convict somebody under the reasonable doubt standard for many crimes that would have an intent element. Yes, they are well equipped and able to do so.
Okay, but correct me if I'm wrong, this clear and convincing standard to prove intent is not usually used in order to get evidence into admit evidence. You're talking about the ultimate decision that the juror or the trier of fact, the judge, would have to make in the case. We're not talking about an evidentiary standard, are we? Are you aware of any other situations in which, in order to get evidence admitted at into a trial, the proposer of the evidence would have to convince the judge by clear and convincing evidence about someone's intent? Give me another example where that's happened.
Well, I give you an example about, yes, Maryland Rule of Evidence 5-404B provides that evidence of other crimes, wrongs, other acts is not admissible to prove the character of a person in order to show action and conformity therewith. Meaning you can't bring up other acts or other crimes the defendant has done to show that they're guilty of the crime they're currently charged for.
And is the standard in that case the clear and convincing evidence standard?
Yes, Owens v. State, a Maryland Court of Special Appeals 2019. Before such evidence can be admitted, 504B evidence, the trial court must engage in a three-step analysis. First, the court must determine that the evidence speaks to one of the permissible purposes specified in Rule 5-404B. Second, the court must determine that the accused's involvement in the prior bad act was established by clear and convincing evidence. Third, the court must balance the probative value of the evidence against any undue prejudice that will result from its admission. So yes.
Okay, and does that evidentiary standard relate to intent? What's going
Depends
on in
on-
someone's mind?
If the prior bad act that the government wants to use is another crime, and there's an intent element in that crime, then yes, the government has to show by clear and convincing evidence that that person had the intent in committing that crime.
Then wouldn't you simply have to establish the prior bad act and to show that it's similar to the current bad act?
No.
Where does intent come into play?
You have to show Second, the court must determine that the accused involvement in the prior bad act was established by clear and convincing evidence.
But there's no intent component there. It's just an act. An
If the-
act proves itself. That the effect that the act occurred proves the act occurred, right?
If the other crime has an intent element, the government would have to show that the defendant's involvement was established by clear and convincing evidence, that they had the intent in doing that other crime, if intent is an element of that crime.
Okay, I think we're going to disagree on this, but I thank you very much for your answers to my questions.
Actually, thank you, Mr. Chairman. I think Senator West covered it because my question was really, I think, Senator West, whether you're doing preponderance, clear, or convincing, or beyond reasonable doubt, that goes to, what you've proven against the defendant. My understanding of the federal rules of evidence for which Maryland is modeled after, and in both state and federal court, the evidence, the general rule is, whether it's probable, probative and competent. So other than the rule you just mentioned, which I tend to think is not applicable, is there any place else that you're aware that evidence can only come into court, not based on probative value versus balanced against prejudicial, but requires clear and convincing standard?
Other than the one I just said,
Right.
I do not know, but
Okay.
just as a matter of fact, every piece of evidence has to go through the relevance and the probative value.
Right, yes,
analysis.
that we agree on. And then I didn't get a chance to read Montague in its entirety, but I did not see the court referencing in what little I could read this clear and convincing standard. So I know you've been saying, I think if I understand you, that this is a codification of Montague, but I don't believe the court had that particular language that that you have in the statute. Am I wrong about that?
I do not recall seeing clear and convincing in my.
Okay. And then are you familiar, this was in written testimony by the Howard County State's Attorney, a case called Hannah v. State. Did you bring that case up and speak to it?
I am familiar with the case. In that case, the court ruled that it was the trial court improperly and allowed the introduction of rap lyrics for impeachment purposes because the rap lyrics didn't have a connection to the facts of the case. And so it again is following the same principle that if you want to use rap lyrics, you have to first show that the lyrics have a direct tie to the allegations of the case, the charge or the charge conduct.
Which I think Montague stands for that proposition.
Right.
Okay, so the court has spoken on how this evidence would come in.
Yes,
It's
and
not
as
clear and convincing,
And
right?
as I said,
But it does have to have a nexus, and then you would apply the general probative versus prejudicial and the otherwise being competent. So we do have a structure, do we not, for allowing or disallowing this kind of information?
there is a structure, but as I said earlier, that precedent is not sufficient in my eyes because precedent can be changed much easier than codified law. And two, courts and judges are able to circumvent or sidestep precedent by just saying, well, this fact in this case makes it different, so I don't have to apply that.
Well, that's
precedent.
true, because in all cases, you have to take that particular case and those particular facts. So it is kind of hard to legislate in this area when, in terms of giving the court the ability to balance out based on the facts of any particular case. Every case turns on its particular facts.
Yes, but all the cases also turn on the rules for how judges are to do that
true,
analysis. And so, I mean, if you want to say, well, judges should have the discretion, then just get rid of all the rules of evidence and just let the judges just do what they do. But no, we say, yes, you have discretion, but here's the guidance and the standard that you are to impose. And what we're saying with 662 is that taking the words of the Montague court saying rap lyrics are inherently prejudicial, so a guardrail is needed. That was what 662 does. And it puts a guardrail that judges have to apply regardless of the facts, and they then can't say, well, because of this fact in this case, I don't have to follow Montague.
Just give me 1 minute. There was one last question I had, and I don't know if I can find it now. Bear with me. All right, I can't find my last question, but thank you for engaging with me. I appreciate it.
All right, can I just, I'll very quick, sorry, Sarah, come back. Thank you. This has been really great, actually. So thank you very much. It's been very instructive. Just real quick, just tying a bow up on this. The bill, it seems to me, and if I'm mischaracterizing this, just correct me. You're trying to codify the holding in Montague as a first step. But it seems as though you also want to apply the clear and convincing standard for admission of that. Is that because I'm trying to understand what we're doing, why and I understand your difference between common law and statute and the variability there. But just bottom line up front, you're trying to codify this ruling and then establish a clear and I know clear and convincing is kind of in Senator Carter is probably the most apt to answer this question. You do this work every day. Clear and convincing is a standard for a number of rules of evidence, like a statement of an unavailable witness, character evidence, all of those things are clear and convincing to get into evidence. So I understand where that's happening, but if you could just give us like a bottom line up front, okay, codify Montague, and then what? Am I missing something?
No, I think the clear convincing standard reflects what the Montague court says is that because of the inherently prejudicial nature of rap lyrics, there needs to be this. When they use the term direct nexus, to me, a direct nexus needs to be shown by clear and convincing evidence. And so that's why I believe that the standard is appropriate. And by clear and convincing also is that it says, look, there's been enough of a showing that these lyrics are actually reflective of the facts of the case because they're so inflammatory and can appeal to so many prejudices of a fact finder, a jury, or a judge, that we need clear and convincing. And so that higher bar is needed because the lyrics are so inflammatory. And I think that is what is reflected in 662, going back to Montague, that because they are so inflammatory, we need to be clear, and there needs to be a clear showing that the lyrics are tied to the facts of the conduct or the charge.
Excellent. Thank you very much. Senator James, did you still have a question or that's on? Okay, excellent. Okay, thank you very much. All right. Thank you. Seeing no more questions. Thank you all very much. It's been very helpful. Thank you for the time. All right, so we can hear from now Sarah Wendell. Is Mr. Love here? Davon Love. Nashona Kess, Ms. Kess. Okay, welcome. Mr. Love's right behind you, so you can go ahead and start it.
Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Sarah Wendell. I'm an assistant public defender here in Anne Arundel County. And the Office of the Public Defender is coming to you in support of Senate Bill 662. I know you just heard quite a bit of discussion about how this would play out in the courts, but from a practitioner's perspective, the difference between having the case of the Montague versus State close nexus test to be applied in court as compared to having a statute that lays out a specific framework for what standard needs to be applied and what inquiries the court needs to parse out before a piece of evidence can be admitted would be extremely helpful. How to treat music and creative expression in courts of law is being litigated nationwide. And as you heard, even after the Montague case, the court did not have a specific statute in that case to look to clarify what the legislature would how the legislature would address this issue. And we are seeking this clarity from you all today, especially where evidence may be sought to be introduced that has First Amendment dimensions. I would be happy to elaborate more than questions, but again, I do know that you already had a lot of questions here today, but the rules of evidence as they stand do not adequately protect elements of creative expression, which are broadly and consistently protected by our First Amendment and the longstanding traditions within the United States. And the staying power of the internet and social media has only amplified this need, and it is a need that we are seeing in courts, especially with our clients that may be young and maybe amateur artists who are working on their music. And this is something that we are considering and could have a chilling effect on their creative expression. These small requirements embedded within the PACE Act do strike the appropriate balance of allowing the state to introduce evidence where it meets those requirements, but also having the courts parse out what really should be coming into evidence and what is unduly prejudicial. And for these reasons, we urge a favorable report.
All right, good afternoon, Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. But in addition to that, my organization was also a part of forming and founding the Pennsylvania Avenue Black Arts and Entertainment District. So I'm also speaking with that hat on as well. One of the only arts districts in the country explicitly focused on arts and entertainment for and by Black people. And so that brought me to testify in support of this piece of legislation. Again, I know that already a bunch of conversation happened prior that's relevant to my remarks, so I don't want to reiterate. I just want to emphasize the piece around the way in which the narratives of people of African descent and popular culture that are highly circulated often emphasize notions of inherent criminality and violence amongst Black folks. So that's there's a whole slew of evidence. There's a Tony Weaver study, a brother from Elon University, that looks at nonlinear media that says that about 60% of the characters represented in popular culture reinforce some of these racial stereotypes. There's a bunch of evidence that talks about the way that it impacts decisions that are made about the kinds of policies people support. And one of the things that I just want to emphasize is that as it relates to the way that these narratives are weaponized against Black people, the use of lyrics, and again, a bunch of the previous testimony, I think, speaks to this beautifully, is that the use of the lyrics of a particular artist, particularly Black artists, in this context, is essentially weaponizing these notions of inherent criminality and violence in ways that are distinctly resonant when it comes to Black people from certain communities and neighborhoods. And so, we are folks that, given the Black Arts and Entertainment District and the work that LBS has put in building that, we just don't want to subject, particularly artists that come from the neighborhoods that we represent, to be vulnerable to those kinds of weaponization in the context of the criminal justice system. Thank you.
All right, questions from the committee? All right, seeing none, thank you. Oh, I'm sorry, Senator James has a question.
In addition to the rule that the proponents mentioned, I hope it was 5-404B, right? I also found another Maryland rule, I think it's 10-923. Kind of similar, you might be familiar with it. It's if the defendant, the prosecutors want to admit evidence of prior or even later, actually, sexually assaultive behavior. In that, that's sort of another bad act, right? Mm-hmm. The standard again there would be, I think it's clear and convincing. But here's my question. So far we've located a couple of rules that relate to behavior or bad acts. But are you aware of any other situation that's similar to this particular proposed law, which has nothing to do with prior bad acts or post bad acts? It's not a behavior, and it's also behavior that's not in and of itself related to criminality.
And thank you for your question. I actually do believe in the common thread between all those rules, as you said, is the propensity arguments that can be made at trial or in sentencing or any other proceedings. And I actually, though I definitely agree with you, right, Senator James, that's the primary category of rules we're looking at.
Okay.
I think what the PACE Act is trying to also protect is propensity arguments that can be made against a person who is accused of a crime or delinquent act, and the state is seeking to introduce elements of their creative expression, because the studies do show that creative expression, especially music videos, when introduced at trial or to a judge, can have a very persuasive impact on the propensity of what juries might believe about a person, the biases they may have. So I actually think it's a common thread throughout those rules that is applicable in this case. And I do want to point out that though it's a different context, the First Amendment case law broadly, it is, again, a different context than in the criminal justice system, but as a fundamental right, it does receive strict scrutiny in other contexts. So back into the criminal justice system, we are asking and believe a higher standard would be appropriate to adequately protect those constitutional dimensions.
You did a nice job answering that, even if we don't completely agree. And I get the thread of propensity, because that what I'm challenged by is that this has to do with, what's in somebody's mind. So so that's kind of the question. And I think the answer you're giving me is that, as far as you know, in Maryland or elsewhere, we don't know of any statute that's creating basically a rule of evidence that would combine both the worry of propensity, clear and convincing, and then taking it out of behavior and putting it over here in this much more nebulous area of intent, right?
Well, I do think Rule 5404B, one of the exceptions is intent, and that would have to be proved by clear and convincing evidence that prior bad act evidence can be offered to show intent. So I do believe that this all falls within the same realm of applicable standards, because we're still getting at the same thing. It's just in a different context.
And then let me just ask you this one last question. I tend to believe that in the jury system, the juries can sift through, and good lawyering, I think lawyers say a lot of flamboyant things, and can get some evidence and get evidence in that's circumstantial and surrounding. But I have a kind of a confidence in the jury system. Is this bill really reflecting a lack of confidence in juries?
I think what the bill is reflecting is what the studies have shown, that there have been numerous universities. Dr. Nielson was one of the primary leaders in that. Numerous studies that have shown that rap music, hip hop music, there are particular types of art that do actually can be misconstrued and misleading to juries based on our own common biases within the community. So I would say that this is reflective of those studies.
And is that whoever proponents of the bill, could somebody send me a couple of just the title of the studies and the authors? Okay, and I'll look them up. That would be very helpful. Thank you, Mr. Chairman.
Senator James, you make an excellent case for the voir dire expansion and also expanding the jury pool as well with Senator Carter's bill. You make an excellent case for both of those bills. All right. So let's get those studies to beef up everything. There you go. All right. Thank you both very much. Thank you. All right. With that, that'll conclude the testimony in the hearing for the proponents of the bill. We have one person signed up in opposition. Joining us virtually, it's Eric Nielson.
No.
Sorry, that's my apologies. My apologies. That's favorable. Dylan Young. Is Dylan Young from the Howard County State's Attorney's Office?
He is not on the Zoom.
Okay, Mr. Young is not on the Zoom. Oh, excellent. How are you? Welcome. Good. How are you? Floor is yours. Welcome.
Good afternoon. Thank you, Senator Smith and the rest of the Judiciary Committee for this opportunity to address you today. My name is Dylan Young. I'm an Assistant State's Attorney, and I'm here on behalf of Richard Gibson, the State's Attorney for Howard County, and the Maryland State's Attorneys Association. I'm here to request an unfavorable report on Senate Bill 662. As a prosecutor, my job is to hold criminals accountable for their actions. That job becomes more difficult when we erect artificial barriers that prevent us from using relevant evidence created by alleged perpetrators. Senate Bill 662 creates such barriers. First, as mentioned earlier, this bill concerns an issue that's already been addressed by our courts. The Supreme Court of Maryland has established a framework for determining the admissibility of creative expression, particularly in the form of song lyrics. The court has held that such evidence is admissible only when the lyrics bear a close factual and temporal nexus to the details of the alleged crime. The courts have demonstrated that they can balance the state's interest and the defendant's First Amendment rights. In another case, the court held that the state could not use a defendant's song lyrics when they fell within a category of, quote, inadmissible works of fiction. By attempting to codify criteria that has already been effectively addressed by the courts, this bill risks introducing unnecessary complexity and confusion into our legal framework. I recently tried a murder case in Howard County in which the defendant, while incarcerated and pending trial, authored song lyrics that described the crime in detail and contradicted the statement to which she gave police. We were able to hold this murderer accountable and provide justice to the victim's family, in part because the jury was permitted to consider the defendant's lyrics, which were introduced according to the existing legal framework. Second, criminal prosecutions, by their very nature, involve both direct and circumstantial evidence. The proposed provision requiring unique probative value restricts the prosecutor's ability to present circumstantial evidence. I appreciate your time and attention to this matter. I'm here to seek an unfavorable report from the committee on Senate Bill 662, which will have the unintended consequence of making our communities less safe. Thank you.
Thank you, Mr. Chair. So the Montague decision, I assume you're familiar with that.
Yes.
The opinion was offered during the testimony of the proponents that this is an attempt to codify the Montague decision into statute. And it's better to do that than just leaving it a matter of case law. In your opinion, is this proposed statute merely a codification of the Montague decision as written?
I don't believe so.
What's different?
As mentioned earlier, I do believe that it applies a clear and convincing standard that is not mentioned within the Montague decision. Additionally, the provision in which that requires the last provision in the statute that requires unique probative value to that that piece of evidence, that creative expression, is also absent from the Montague decision. So I think this creates a much higher bar for the admissibility of this type of evidence than stated by the court in Montague.
Well, let me ask you another question too about this clear and convincing standard. Are you aware of any other, when you're a prosecutor, you're in court all the time, and you try to get evidence into information into evidence in front of the court for the court's evaluation. Do you have to overcome a clear and convincing standard to get other evidence into evidence?
The only one I'm aware of was mentioned earlier. The only one that I've dealt with personally. I understand there's other situations where the clear and convincing standard may be applied, but most commonly is used in the context of other prior bad acts in Rule 544B. Other than that, I'm not aware of any standard that's been applied by the courts or the rules of evidence.
And when you're talking about other prior bad acts, you're talking about an act, correct?
Correct.
Something that can be introduced as an objective fact that a prior bad act occurred.
Absolutely.
Right? Now, in this proposed statute, the language is that you can't get creative expression introduced into evidence unless the court finds by clear and convincing evidence that the defendant intended the creative. Is there any other case that you're aware of, any other situation in which in order to get evidence into evidence in court, you have to establish to the satisfaction of the court by clear and convincing evidence that someone had an intent?
I'm not aware of anything that says that explicitly. Obviously, when you try to prove a prior bad act, you have to prove that the person intended to commit that act. Right. But there's no rule of evidence that I'm aware of that requires to specifically prove intent to admit that evidence.
And then how, as a state's attorney, would you go about trying to prove intent by clear and convincing evidence? Would that be easy, hard, or nearly impossible?
Because that is by proving it by a clear and convincing standard, just for the admissibility of evidence is not the typical way we admit evidence in a criminal trial, other than the context that we've already mentioned. It would be challenging in the sense that of course, we prove intent every single day as to the merits of a case. And the way you prove intent is by a number of ways. You can have a witness who says that the person who wrote this, was the author of this creative expression, told me what they meant. Obviously, that happens rarely, if ever. But it is inherently a difficult thing to prove.
Okay, thank you.
Thank you for being here. You had written in your testimony, and I believe you also stated during your oral testimony, that by attempting to codify criteria that has already been effectively addressed by the courts, this bill risks introducing unnecessary complexity and confusion into our legal framework. And I'm still trying to make certain that I'm understanding what is the unnecessary complexity, and then I'll ask what's the unnecessary confusion.
The unnecessary complexity and confusion in this, with this bill would, number one, be applying a clear convincing standard that does not otherwise exist. It would apply a clear and convincing standard that does not otherwise exist for this type of evidence. And number two, the last provision, which requires that the creative expression has probative value that cannot be provided by other admissible evidence, I believe would effectively render this type of evidence in practice largely inadmissible, because in any criminal case, evidence is presented against a defendant who committed a crime or is alleged to have committed a crime, both by direct and circumstantial evidence. There is not going to be a trial in practice in which the only evidence against a defendant to a particular issue is that defendant's creative expression. No prosecutor would go forward on that case. A defendant's creative expression only corroborates other types of evidence that already exist in the case: direct evidence, witness testimony, forensic evidence, and so forth. And so it's only one small part, an important part of building a case against a defendant.
So, and I haven't been in the courtroom to see the case that you were talking about, but in that particular case, was the defendant, says that the defendant authored song lyrics which described the crime in detail and stood in stark contrast to his statement to the police. Could you go about how was he the sole author of the lyrics? I mean, how do you determine or go about trying to determine that?
In this particular case, we believe he was the sole author of the lyrics. The lyrics were recovered from his jail cell.
Say it again.
The lyrics were recovered from his jail cell. There were also other communications made by him on jail calls where he indicated that he had authored such lyrics.
And no one else did?
No.
Did he rap them as well?
At some point, I believe so.
How would you, as a state prosecutor, I guess, make that determination as to that person's nexus to the lyrics? It was talked about earlier how sometimes you have not only your ghostwriters, you have many people who are part of that particular work. From a state's attorney perspective, how do you go about dealing with that as an issue?
As I said, in this particular case,
no, I'm talking about just in general. How would you, not this case that you had, but
okay,
in general, how do you deal with, how would you have to deal with that?
So is the question how I would deal with proving that the defendant was a person who authored the creative expression?
Well, if let's say there are multiple people who authored it, how do you then go about creating that nexus to the defendant that you're trying to pin the lyrics on?
If multiple people authored one song, is what you're saying.
Mm-hmm.
Yeah, that would be extremely difficult to admit that piece of evidence in court, and it would unlikely come in under the existing legal framework. Okay.
Under Senate Bill 662, do you think, would that bill have stood in your way of or prohibited you from going forward with this particular trial that you dealt with?
Yes.
Which part would have made it difficult to go forward?
The last provision would have, I believe, excluded this piece of evidence because we had other evidence that would
that's number 4?
Issue. I'm sorry?
The creative expression has probative value?
That cannot be provided by other admissible evidence. That last clause.
That part would have prohibited you from going forward this case that you wrote
because
about?
because the probative value that the creative expression offered in that case was provided by other probative evidence, including witness testimony and so forth.
Say it, I'm sorry, I'm having a hard time. Say it again.
So the probative value that's offered by the creative expression in the case that I tried was also provided by other admissible evidence that was in the trial. There was obviously other evidence in the trial that indicated the defendant was in fact the person who shot and killed this young man. That included witness testimony. Because my interpretation of this proposed bill, that provision would have excluded those rap lyrics.
Oh, all right. All right. So I'm reading B4 says, in any criminal proceeding or juvenile proceedings, the creative expression of a defendant or respondent is not admissible against the defendant or respondent unless the court finds by clear and convincing evidence that, for the creative expression has probative value that cannot be provided by any other admissible evidence. And you're saying that would have been a roadblock to prosecuting?
Yes, that last provision where it says that cannot be provided by any other admissible evidence.
Maybe I misheard you, but didn't you say that it had probative value?
No, we're not disputing it doesn't have probative value, but it had probative value that could have been provided by other admissible evidence. Those last 6 or so words.
Okay, I'm gonna leave it alone.
No, this is like one of the more highly technical bills actually than you realize on its face. And so, I mean, the Montague decision, we were just talking to counsel, dealt with, is it 5403 prejudice and 5404 bad character. There are a couple different prongs for each rule. And I think it's very, you almost need to like whiteboard this to understand this. So if we decide to move forward to discussions, we'll get a whiteboard out and you'll kind of break down the elements of each rule and understand how this works. So thank you very much. If there are no further questions. Oh, Senator Charles.
Thank you, Mr. Chair. You mentioned you had support from all of the state's attorneys, but I only see 2 letters. You said you were speaking on behalf of all the state's attorneys when you originally gave your testimony.
After discussion with
State's Attorneys Association.
After discussion with my boss, Richard Gibson, State Attorney for Howard County, I was instructed to represent the viewpoint of my office and the Maryland State's Attorneys Association.
Okay, how do you guys typically go about getting the support of?
I'm not involved in that process.
You're not?
No.
But
I'm just a line prosecutor.
But typically, you know, you would have one letter as opposed to just 2 separate letters from 2 state's attorneys. It would be a joint letter with probably everybody's signature on it.
Again, I'm not aware of the process.
So that I'm just looking at that in terms of the interpretations. You know, that's a part of this bill is about interpretations and how people look at things. And like right now, I'm interpreting that it's not all the state's attorneys, but only got 2 letters. And not a letter from all of the state's attorneys' offices. You also, you mentioned a case that my colleague, Senator Sidnor had brought up. And it sounded as if there was clear and convincing evidence that was brought up when you actually took the lyrics and there was a true nexus that was already developed based off of his lyrics and the clear and convincing evidence that came from the case. So how would this bill harm that? I know my colleague asked it another way, but I'm trying to figure out where you find the artificial barriers that you mentioned, because if you're saying you have the evidence, you have his lyrics, they matched up with what actually took place, so you can actually prosecute. And this bill is saying you can still do that with the clear and convincing. If this is clear, this is a true definition of clear and convincing. You actually help the case at this point, help the bill by bringing up the case you mentioned, because it's clear and convincing.
So I think what I was trying to explain was provision number B4, which states creative expression has probative value. And then the key section, I think, is that cannot be provided by other admissible evidence. let's say, for example, in a case, someone had written song lyrics that said that they had shot and killed someone and it was not self-defense. If there was, for example, live witness testimony, someone who saw the shooting and said that that person shot that young man and it was not self-defense, that would be what that witness testifies to, would be, quote, other admissible evidence. So because this creative expression is provided by other admissible evidence, this statute, that provision, would bar the admission of those that creative expression.
Okay.
Thank you, Mr. Chair. Just one last question, request. I think the point was made that there is no letter in the file from the State's Attorneys Association. That's customary. Could you go back to Mr. Gibson, who I think is the president of the association, and ask him to ask the association to send us a letter indicating their opposition to this bill?
I will certainly do that.
Thank you.
Just in the example that you were talking about, if you had the evidence, then would you have, all right, and I'm trying to follow your example. So and I think you said you would have the evidence. Would there then be a need for this additional evidence if you already have something else that can be introduced?
Because of the nature of prosecution is we never have one piece of evidence. There's never really a smoking gun. You build a case by circumstantial evidence. People, and a good defense attorney will say that witness who saw what happened isn't telling the truth, or missaw, didn't see what happened, or wasn't able to see what happened, or is misremembering. So that's why other pieces of evidence, forensic evidence, statements by the defendant are admitted to corroborate that witness testimony. That is the very crux of criminal prosecution.
But if you have this other evidence, I mean, I guess one could look at the lyrics as being prejudicial. So why go that route and use something that may be prejudicial?
Any evidence that tends to prove a defendant's guilt is considered prejudicial. The key question, though, is whether it's unduly prejudicial and it's outweighed by its probative value. That's a determination courts have been making for as long as I've been attorney.
Thank you.
All right, further questions from the committee? Seeing none, thank you very much. It's been very helpful.
Thank you very much.
And with that, that'll conclude the hearing for Senate Bill 662. Thank you very much, Senator Charles. We'll now move on to Senate Bill 1096. I want to make sure that Eric and Linda are going to share out here too. Eric and yeah, you sit on the side of it. Thank you. You sure? Yeah. If you, yeah. All right, members of the Senate Judicial Proceedings Committee, Senator Smith, for the record, here to present Senate Bill 1096, a bill which facially actually is I think pretty easy to describe, but some of the mechanics and the actual functioning of this bill get a little bit more difficult, but nothing that's insurmountable. And I think we can find a path forward this session to get this bill done. The idea for this bill actually came to me from Linda and Eric, who you see sitting to my right, to your left, right here, two constituents and friends of mine. Took me out to lunch. Well, I took them, we paid for each other, but we went Dutch. Got to keep it on the board in case Dia Daly's watching. And we went out to lunch together, and they brought us here. They brought me to to describe an idea that had been on their mind for a number of years. And obviously, as this committee wrestled with police reform several years ago, and obviously images of Freddie Gray and George Floyd and so many others have been ingrained in our minds, not only throughout the state, but all throughout the country. Public safety and the safety of our young folks moving about and through society has been top of mind, especially for, and particularly for young African-American men. And that was the lens with which this conversation took place. And so Eric sat me down and explained to me that folks with invisible disabilities face particular peril in certain social interactions, and in particularly with law enforcement, which can complicate things because the disability is not readily visible and is not something that is outwardly projected, and can complicate an interaction between that individual and law enforcement. And they shared with me some just very personal stories of not only their own, but also of relatives and friends and associates. And so their idea was to have an indicator on your license or on your ID that indicated that someone had an invisible disability, so that when someone was asked to furnish their ID, there'd be a demarcation on the license that would then help that law enforcement officer understand and adjust their interactions with that individual moving forward. And many states have taken this measure in the last couple of years, Mr. Chairman. And so what the bill does is it allows for the option to have an ND noted on the driver's license or identification card. And the non-apparent disability, or the invisible disability, includes Alzheimer's disease, autism, deaf or heart or hearing impairment, developmental disabilities, intellectual disabilities, mental health disabilities. And the bill says that the MVA may not require proof or documentation of a person's non-apparent disability. This just gives us another tool to ensure that those interactions between folks with invisible disabilities and law enforcement don't devolve into something potentially tragic. This bill has the support from law enforcement officers across the state. This bill has the support of our distinguished state's attorney from Prince George's County and Montgomery County, though you'll hear testimony from in a little bit. But most importantly, the bill has support for folks directly impacted and could help save lives and ease those interactions. So supported by both law enforcement and folks within the community. I will note that some of the complications that I spoke at the top of the bill hearing include things like if you have to go through, if you put this on your license and you're under 18 and then you graduate, you want to remove it from your license, then there may be a record on file within the MVA, which could potentially impact things like insurance or how you get your license again, how you renew your license because of the testing that's required. We believe that there is an option forward for that. There's an ID, a state issued ID that does not require that type of licensing or testing. If, however, that person then wants to migrate over from the ID to the license, the MVA would have that record. So we're still working through some of those mechanics. There is also, you may have heard about a blue card, which is something that this legislature in a prior iteration of this bill, I think it was born out of those conversations where the MVA went ahead and took that proactive step and created a blue card, which is something you would carry separately. That's not as user-friendly as this option. You can lose your blue card. You can forget to carry it with you. You always have your license with you. You always have your ID with you. And so we think that this is an enhancement to that process. And we thank the MVA for taking that step forward, but we believe this is the better option. So with that, committee, I'm going to stand by for questions. I want Linda and Eric to go first. They have, if it's okay with the committee, would like to sit and provide their testimony as opposed to standing up just for their own comfort and just for their own comfort. And then I'll stand by for questions after the state's attorney and our two law enforcement officers. We have our sheriff from Montgomery County here as well, who joined us. And with that, I'll ask the committee for a favorable committee report, and I'll stand by for questions afterwards.
Do I hit this?
Yep, there you go. You're good.
Thank you, Chairman, and the members of the committee for the opportunity to speak on behalf of Senate Bill 1096, aka Eric's ID law. My name is Linda Kim Carpenter Grantham. I am here to support my 19-year-old son, Eric Blessed Carpenter Grantham, who is highly functioning autistic. Eric is on a mission to help save lives for people like himself and others in the world who have invisible disabilities. We would appreciate having the option for a voluntary selection to have something identifiable on the Maryland state IDs. I ask for favorable report for Senate Bill 1096, AKA Eric's ID law. So when George Floyd was killed, I realized that I have an African-American son who has an invisible disability. I realized I needed to have a conversation with Eric that he could comprehend. So I sat him down and I said, Eric, what if you and some of your friends went to the movies and something broke out in the movie theater and the police came? They didn't know it wasn't you guys that had this problem, but they come to you. And they're shining flashlights in your face and they're saying in an authoritative voice, put your hands up, put your hands up. I said, put your hands up. Do not reach for your phone to call me because that could become dangerous because that's his first instinct is to always call me for everything. I said, yell out, I have autism. Yell out, someone call my mom and yell out my number. He started to cry. He said, Mom, I could do that, but the police would shoot my friends that have autism. This is when it became a true reality in that moment. Eric, with such urgency, said, Mom, we got to do something. We got to do something and we got to do something now. Because he was thinking about what if something happened to his friends or himself. So this is when Eric came to me. He has a true passion for God first and politics second. He came to me, he said, Mom, could you please take me to Congress? I would like to have a conversation with former speaker at that time, Miss Nancy Pelosi, about laws for people like me and my friends so that we can be safe should we be stopped by the police. I said, Eric, I'm proud of you. I'm going to do my best to get you there. Then he came to me, he said, Mom, I have an idea and I'm going to let him go from here.
Thank you, Mr. Chairman and the committee for the opportunity to speak on behalf of Senate Bill 1096, aka Eric's ID law. My name is Eric Blessed Carpenter Grantham, and I have autism. I'm here because my mom have a talk with me. If I ever get stopped by the police and I have autism, which is a invisible disability, she told me to put my hands up and don't reach for my phone because that could be dangerous. Yell out, I have autism, and yell out, call my mom, and yell out my mom's number. I started to cry, and I told my mom about I can do that, but the police would shoot my friends because autism is different for everybody. This is when I went to my mom and I told her, can I put the logos on the driver's IDs for people with visible disabilities like autism, mental health, hearing impaired, and the visible disabilities. I want me and my friends and others that have autism and others with visible disabilities to be safe if we ever get stopped by the police. I'm going to ask my friends and the parents that have autism to please stand up. And disabilities.
You guys stay.
Thank you. You can maybe see it. I would like the option to have voluntary selection on the Maryland State ID for me and my friends and others that have autism and visible disability. I asked for the favorable report for Senate Bill 1096, aka Eric's ID law, because we need change. Thank you all.
Very proud of you and proud of what you're doing for a situation that affected you. So thank you for being here.
Thank you.
Thank you Mr. Chair and members of the committee. For the record, I'm Aisha Brave Boy, State's Attorney for Prince George's County, here to testify in support of Senate Bill 1096. I would first like to thank Eric and his beautiful mother for the idea for this bill. In fact, they traveled from Montgomery County to Prince George's County to present this bill idea to me. And I said, immediately, I said, yes, I'll support you. I'll do whatever I can. I'll introduce you to whoever I can introduce you to, because I thought it was really important that we focus on the preservation of all life. And I know that when law enforcement interacts with our residents, our constituents, that's what we expect. We expect them to place the preservation of life as the highest priority. But in some cases, it does get difficult, and you'll hear from law enforcement, our law enforcement partners, some of those interactions get complicated. And I think well-meaning officers may interpret the actions of, individuals in our community in a way that they did not intend because of their invisible disabilities. I think knowledge is power. The more we know about who we're interacting with, the better we can treat them, the more appropriately we can treat them. And I think that's very important. The fact that law enforcement is here to support it means a lot, because no one in law enforcement wants to hurt someone. I believe all good officers want to interact with someone in a way that preserves their dignity and their life. But our officers are called upon to do a really difficult job. And sometimes they have to confront tough situations. The more information they have about the individual who they're interacting with, I believe the better the outcome. And I believe that lives will be saved. So thank you so much to Eric and his mother. Thank you so much to Chairman for sponsoring the legislation, along with Senator Michael Jackson from the 27th district, in Prince George's County. Thank you all for your leadership. Thank you. Thank you.
Good afternoon. I'd like to thank the Honorable Chair Smith, Vice Chair Wallstreicher, and members of the committee for allowing me an opportunity to present today. I am Sheriff Maxwell Wee, the Montgomery County Sheriff's Office, and I support Senate Bill 1096. The Montgomery County Sheriff's Office, the oldest law enforcement agency in Montgomery County, is currently the law enforcement arm of the court system and complements the mission of the allied law enforcement agencies throughout the county. Whether serving papers or orders of protection, criminal or civil warrants, or during court proceedings or other actions, our staff interacts with members of our diverse community daily. This proposed law would allow individuals with non-apparent disabilities to voluntarily apply to indicate such status with the uniform notation ND on their Maryland state driver's license or identification card. Such an identifier serves to communicate that a non-apparent disability exists at a time when law enforcement or first responders are attempting to initially assess the situation. As a law enforcement leader, I recognize the potential for tragic results that always exist when a misunderstanding occurs in communication between public safety professionals and individuals who may have physical, mental, and/or neurological conditions that are not immediately obvious or visible. Providing this proposed mechanism to allow for notification of that status on individual licenses and identification cards could go far to avoid such tragedies during encounters with law enforcement personnel or first responders. The knowledge this information provides may have added benefit of de-escalating a situation where lack of information may otherwise provoke tragic consequences when law enforcement or first responders are unable to understand individuals' non-compliant behavior. I applaud the efforts of Eric and Linda Carpenter-Graham, along with the sponsoring legislators, to address the safety concerns of these individuals with special needs and their interactions with law enforcement professionals. I'd like to thank the members of the committee today for their time and attention, and urge for a favorable report for Senate Bill 1096. Thank you.
Good afternoon. I guess I'll be brief, as pretty much everybody who came before me was able to lay out. I am Sheriff John Carr. I'm the Sheriff of Prince George's County. And I would like to say I came into contact with Miss Linda and Eric maybe a few years ago. And I believe it was well said by our Sheriff of Montgomery County that we have a tough job, and also our Prince George's County State's Attorney. We have a very tough job. And our job is to make sure that we're able to take care of our citizens. In order to do so, we must have the tools and abilities and training to address every and any issue that we may come across. August 24th, 2019, Colorado actually has this identification as far as invisible disabilities. You have an example of Elijah McCain, and many people may not know was a gentleman who actually had an invisible disability and came into contact with law enforcement. Unfortunately, that resulted in a tragic response in their interactions. When Eric came to me and brought this, I knew it was something that we had to do as law enforcement to make sure that our citizens feel safe. I knew it was something that we can do and to articulate amongst our law enforcement brothers and sisters to make sure not only people with invisible disabilities feel comfortable, but also their families and their parents. And I'm happy to see here today many of those families and many of those individuals with invisible disability here for support. I am asking for a favorable report because we are here to serve our citizens. And in serving our citizens, this is what they are asking for. This is something that is voluntary. It is something that they feel safe by having on their ID, and it's something that I know we can do. I would like to ask for a favorable report, and thank you for your time and attention, Mr. Chair, members of this committee. Thank you.
Thank you. Thank you, Mr. Chair. I got a question for Sheriff Carr. I think you need to go back to the podium, I'm afraid. You're only on camera if you're at the podium. I think this is a great bill, but it seems to me even more important than this bill is adequate training of our law enforcement officers so that when they encounter someone who has one of these invisible disabilities, they don't see an ID card. They just see the person. And we need to make sure that the officers are sufficiently trained so that they're sensitive to recognize the fact that this person is operating under a disability. Can you advise us whether or not, in your view, the officers in Prince George's County are sufficiently trained in order to be able to recognize disabilities in people who have them?
That is a very great question, and I'm glad you asked that. I didn't get a chance to actually mention Miss Linda actually has a class that she offers here in this region. And it actually involves having individuals with invisible disability in the class, taking the class. We had a retired captain here, Miss Captain Keisha Poole, who was present as well, take the class. In our training, we understand that you can't see visibly what is going on, but our interactions as far as speaking to somebody and having cues on if that individual may have some issues. So when we're asking for identification, if that person is unable to articulate and say no, yes, there's something else that needs to go on, and we need to try to make sure we're able to de-escalate and try to figure out other cues or what may be going on with this individual instead of thinking that it's non-compliance. That's the worst thing that we can do, is to jump to conclusions. We want to take our time. We want to try to verbalize. If the person is unable to verbalize, we want them to feel comfortable enough to then maybe produce that identification card, in which we would then take those additional steps. So we are taking classes. I do say that we do need to take more classes, and classes need to be offered not only just here in Prince George's County, but really throughout the state in dealing with those invisible disabilities, so we can make sure that we can fine tune that.
Terrific. Thank you so much for your answer.
Thank you. I can ask the sponsor, maybe you can help me out. I had two questions. One, just in terms of the blue card?
Yes.
Is it more of a thing of just kind of convenience of taking what maybe how the blue card is used to place it on the identification? Is that the idea?
Yes. So Linda's got one here as well, but I have one which I'll enter into the bill file, which is basically a picture of the blue card. But here it is right here. Which is also a voluntary option. But you'll hear, and I'd have almost defer to Linda because she's the one who told me about I didn't know about the blue card.
Not neither did I.
And so I found she told me about this, and same with Eric. And just it's not a user-friendly option. It's something that can be, you see it right there, but it's something that's not something you can lose, something you won't necessarily always carry with you. It's not as user-friendly of an option as an actual ID, which is something that's a government issued ID, something that I think law enforcement would easily understand and recognize immediately if they're able to look at that. There's training that has been done in some law enforcement agencies on the blue card. And I know there's been some good faith efforts and progress made in that regard, but it's our opinion that this is the better option. But I'll pass it. I'll make sure you get if you look in, I'll make sure this is entered in the bill fund. I'll bring this over to you, but this is what the blue card is. It's a voluntary option.
And on page 3, the definition of the non-apparent disability. I'm curious because as I was listening to your testimony, it triggered my wife. She is a speech language pathologist.
Yeah.
And she had reached out to me because she's had patients who have been missing appointments because of MTA mobility and the like. And I think some of her clients that she works with, they have aphasia. And aphasia is something that can affect your speech and how that works. I'm curious with the definition of non-apparent disability, would the things that are included under it would it be considered would it be a liberal construction when we're looking at things like developmental disabilities, intellectual disabilities, and mental health disabilities? And I'm asking, would we have a liberal construction? Because because it doesn't say aphasia, I would assume that aphasia probably would fall within one of those categories that is mentioned. So I guess the question is, are we looking for a liberal construction of those things under this definition?
So I'm not a clinician, so I couldn't answer that specific question, but one of the things one of the complications which you're going to hear, which are valid, is the medical review process, which is what triggers the complications for the license, not the ID, but the license. And this is done by the MVA through COMAR, this through regs. Oh. And one of the things that they say is the specific disorders for medical review that would trigger that medical review process. Diabetes that has caused low blood sugar episode requiring assistance from another person in the last 6 months, epilepsy, seizure, heart condition, stroke, a condition that causes you to have dizzy spells, fainting, or blackouts, go all the way through alcohol use problem, drug use problem, mental health condition that may affect your ability to drive. Pretty broad. And so I would leave it to the clinicians to that's in COMAR right now, but I don't have the medical background to answer that question more precisely than that. Okay, sure. Yeah, go ahead.
So I just wanted to say that if my son is in crisis and the police are with him and he's in crisis, they're not going to have time to read this blue card versus at some point looking at his ID and seeing on the ID that he has an invisible disability. So I just wanted to point that out.
No, and that's what I was thinking. Unless someone who has the blue card, well, a law enforcement officer is likely to say, "Let me see your ID." They're not going to say, "Let me see your ID," and do you have a blue card? Versus, okay, thank you.
Excellent. Thank you, Mr. Thank you to the sheriffs from Prince George's, Montgomery County, the state's attorney, and Eric and Linda. I think that's it for this panel. We do have some folks from the state's attorney's office from Montgomery County. We have a former delegate from Prince George's County here that was a prior sponsor of the bill that's here to testify. I'd like to have her come up in the next panel as well.
Which one?
Oh, come on.
Hey. Yes.
Last term.
Thank you.
Good to see you and good to have you. Say it again. Denaria Hernandez. Are you still here? Yes. Christopher Follinger. If I said that, I probably didn't say that correctly. But anyone, Christopher, come down. Kimberly Waters. Hector Garcia. Okay, he's there. Christina Hall.
Stacy Brewer. Stacy Brewer.
Stacy Brewer. Okay. And Alan Hernandez. You can sit right here at the table. And there's. Okay, welcome. Take it away. Good to see you.
Thank you, Mr. Chair. Good afternoon. Rachel Jones, former delegate for District 27B, current board member for the ARC of Prince George's County. And in 2022, I sponsored HB 1121, which was a similar version of this bill. It eventually was amended to be a blue sleeve, which is similar to the envelope that you slide your hotel key card in, which wasn't exactly to my satisfaction, but there was, as the chair, and I thank him so much, and Linda and Eric for bringing this bill to the chair, as already mentioned, there was opposition to the bill as it's being presented today. At the time, 17 other states, including Virginia, our neighboring state, already had some sort of notation on the license that would have allowed a person to voluntarily self-identify as having autism or another intellectual disability. My 14-year-old son, Aaron, has autism. He's on the spectrum. And as Linda stated, and as Eric stated, each person on the spectrum is different. Aaron is very high functioning. He's currently an NJROTC. He's a 9th grader. But if you interact with him, he may not make eye contact. He may be fidgety. He may shut down and present it with a situation that makes him uncomfortable or scared, and he may not know how to react. And that was the impetus for me sponsoring the bill back at the time. I understand that there, again, will be concerns or opposition. I'm a person who has a condition that requires me to report annually to the MVA's Medical Advisory Review Board. And so some of the concerns that have been raised, I feel come from a place that don't necessarily address the inclusivity of persons with disabilities, particularly if you have the intersectionality of being a person with a disability and also being a minority or being Black or being female, and possibly having some other issues compounded when you are presented with situations where you engage with law enforcement. And it's great to see the support from law enforcement here today. I respectfully request a favorable report on this bill. Thank you.
Good afternoon, Chair and Senators. Thank you for having me. My name is Kimberly Waters. I acquired my disability on March 1st, 1993 due to an automobile accident. I am a paraplegic, paralyzed completely from the waist down. I use my wheelchair for 100% mobility. As you can see, I have a very visible disability. And unfortunately, because we live in a world where people are such daredevils, the paraplegic and quadriplegic community is growing drastically. I am Miss Wheelchair Maryland 2015, who continues to advocate to the many people living with a disability. I'm a wife, a mother of 3, a grandmother of 2. I work for the U.S. Nuclear Regulatory Commission in the Office of the Inspector General in the Investigations Department. I live in Owens Mills, Maryland. The moment my disability becomes invisible is when I get behind the wheel of my vehicle to get to work or take my grandchildren to the Sky Zone or whatever have you. Some time ago, there was a video of a paralyzed man that was dragged out of his vehicle by law enforcement after pleading that he was unable to walk. This has been a fear of mine since the video went viral. As I said earlier, the population of individuals with physical disabilities is growing, and we are driving. This is important to me because if I'm ever pulled over while driving, I'd very much rather be identified as an individual with a physical disability than drug out of my vehicle, assuming that I choose not to comply. Thank you.
Good afternoon. I'd like to, first off, my name is Robert Hill. I'm an assistant state's attorney in Montgomery County, and I'm here on behalf of that office as well as my boss, John McCarthy. I want to thank Senator Smith for sponsoring this bill, and I also want to thank Linda and Eric for their hard work on this. I had the pleasure of meeting them last summer, and I can tell you that Linda, if you're not a lobbyist, you should be one. Public safety is an absolute priority, and we all understand when the police are interacting with the public, whether it's a traffic stop or a call for a person in distress or whatever it might be. It's important for the police officer to understand the situation that they're dealing with and the person's circumstances. And in this instance, it not only helps the police, but it helps the peace of mind of Eric and Linda and the moms out there. It is, if this bill saves one life, it's absolutely worth it. Absolutely worth it. And I would just note from a practical standpoint, I think I saw something in the fiscal note that if it's on the back of the license, it's not as expensive versus on the front of the license. Either way, the fiscal note appears to be about $25,000 a year, which in terms of saving lives is nothing. So anyway, I urge a favorable report, and thank you again. Thank you.
Thank you, members of the committee. My name is Hector Garcia. I've been a resident of Maryland for 25 years, and I am here to express my strong support for Senate Bill 1096. I am the dad of a son that has a non-apparent invisible disability. He's on the spectrum like Eric, not all the adults behind me. I'm also the executive director of a network of over 50 nonprofits in Maryland and across the country that support the disability and autism community. I believe this bill would provide my son and others like him and Eric, which are gifts to our community, with a simple and voluntary way to communicate their needs and challenges to law enforcement officers, emergency responders, and other service providers. By having a notation on their credential, individuals with non-apparent or invisible disabilities can inform others that they may need extra time, they may need patience, and they may need assistance in difficult situations that can become dangerous and that potentially can help them save their own lives. This bill is simply common sense and a compassionate measure that would benefit both people with invisible or non-apparent disabilities, as well as a broader community, and it will save lives, even if it's just one life, like was mentioned before. And I'm sorry if I'm emotional about this. You know, I fully believe and urge you to vote in favor of this bill and to recognize the rights and the need of people with invisible and non-apparent disabilities, which they are a gift to our community and to the entire state of Maryland. Thank you.
Good afternoon, members of the committee. I am Christina Hall. I am the bonus mother of Rashawn Williams. I had the pleasure of connecting with the Grantham family after the incident of Rashawn going missing back last year. I believe this bill is a necessity in our community and society. Having the option to portray this information on the identification cards can save lives, as well as restore the interactions with law enforcement. As a mother and a grandmother, I have a grandson and an aunt with special needs. It would give me a sense of comfort knowing if they are pulled over by law enforcement or they need assistance, that they can provide this particular information. Specifically in Rashawn's case, he went noticed but unnoticed. Therefore, it's our responsibility to be educated about those with special needs and recognize the signs of those with disabilities, and utilize the ID resource to reduce the impact of the distress that me and my husband and family had to go through in Rashawn's case, as well as safeguard our loved ones. This bill, along with the Purple Alert, goes hand in hand. It's our duty to advocate for those with special needs and enhance the safety and the well-being of our vulnerable members in our society. I think we need to be more proactive than reactive. Thank you so much.
Good afternoon, everyone. My name is Alan Hernandez. I would like to have this ID to feel safer when I go out alone. I don't want to feel scared or anxious when I see the police near me. On the contrary, I want to walk safely in the community. I ask you, Mr. Senator, for your support of this project. Thank you.
Good afternoon, everyone. My name is Sinora Hernandez. I am Alan's mom. I want to say thank you very much for receiving us today and for this great opportunity to speak with you. Also, want to say that it's very important to me that my son has with him an ID when he goes outside, because this ID will protect him of not being mistreated for the police. We can see several cases. The police is not good with some people, right? And the people not always is in trouble, is the people has mental health. Thank you very much for your time.
Thank you, Mr. Chair. First, I want to, say thank you to everyone who came up here and testified on this bill, which I think is a much needed bill. It's an amazing bill. But this question in particular is for Delegate Jones. If you can go up to the podium for me. Thank you. I think it was about 2 years ago on the House floor, you gave a rousing speech about what you went through as a mother with a child with special needs, and never thought much of it. But when you brought the racial bias tied into the already the large massive issues when you're having to raise a child with special needs as well, you tie all of that in. And we did not get the support from a lot of the outside organizations that we should have. Can you just go into a little detail for us about that experience and for those who were not there on the House floor, just so people can have an understanding of what you went through?
Sure. Thank you, Senator. And I'm going to try to maintain my composure. Again, as I stated, the impetus for the bill for me was my own son, being on the spectrum and understanding his challenges and understanding that I've spent his entire life fighting and advocating for him in the school system, and knowing that there would come a day where he will be out on his own. He will be licensed, he will need an ID, he will walk the streets without me, and wanting him to have that extra protection. And so, I'd sponsored the bill and the hearing was coming up. The weekend before the hearing, you all have been there because you, as legislators, know you've got a campaign. I had been door knocking with my two sons who were 10 and 12 at the time. And we were in a community, and mind you, we're door knocking for a primary. And so I'm knocking on doors of my own party at the time. And we're in a neighborhood and my sons they would have a competition where they'd race to drop off my literature at houses. And so we're in a neighborhood, the houses are side by side. My son, Aaron, walked up the driveway for a house where the garage ended at the driveway. And he wasn't paying attention as he approached the house. So he didn't see the pathway to take to the right to the front door. He took the pathway to the left to the back door. I waited for them on the street so I could see both boys running to both houses. And minutes, well, not even minutes, seconds later, my son comes running from behind the house. He's screaming, "Mom, Mom." And then I see 4 adults chasing him. They're chasing him back to the street and they're asking, "What did you take? What did you take? Come back here." And he's running to me. He runs, he gets back, he jumps in the car, puts his head between his legs and starts crying. And I'm standing there in my campaign shirt with my literature in my hand, looking at these 4 adults who have now come all the way to my vehicle. And they're asking me, "What is he doing in our yard? What is he doing in the yard?" And I looked at them and I pointed to my shirt and I said, "I'm your delegate. This is my son. We're in your neighborhood. We're just dropping off some literature." And he was just dropping literature in your yard. And they were like, "But he was in the backyard and he didn't answer our questions and he ran." And I said, "I'm sorry that he went to the backyard by accident, but my son is on the spectrum. And socially, it wasn't going to be his first cue to respond to you or to look you in the eye. And he ran. And I do apologize, but again, we're just passing out material." And they kept saying, "But he should have answered our questions." And finally they said, "Okay, we understand it's a mistake." I knew that only one person lived in the house, but there were 4 people. And they said to me, "We're all retired Prince George's police officers. We're here hanging out with our buddy, and his behavior just seems suspicious." I watched 4 adults chase my 12-year-old child down the street because he accidentally went to the wrong door. And so, as if I didn't already have concerns and want to sponsor that bill, the bill hearing was coming up that Tuesday. This was a Saturday. That Monday, I began making phone calls to some of the disability rights groups who had already expressed that they would oppose the bill. I shared with them what had just happened, and I was told by one, "I'm sorry that that happened to your child, but that sounds like a racial issue, not a disability issue." And at the time I said, it's both, because as I mentioned in my initial testimony, there's an intersectionality between having a disability and people can't tell you have it because it's not apparent, and them expecting you to behave a certain way and you don't. And so it did not change the position or opinion of any of the disability groups. And at the time I had asked, and I am refreshed to see that, at least one of them has increased the diversity of their boards. And as a result, I ended up as a board member of the ARC of Prince George's. But I said, if you have people who are making decisions and recommendations on what bills the disability community is going to support, I would love to see more diversity so that I know that there's a mother or father in the room who's sharing my perspective, who is raising a child like mine, like Eric, like so many others who have stood here today and testified and have the same concerns. And so I know that most of you as legislators have also had a bill or 2 gutted. And so I know you know how terrible that feels. The bill was gutted, as I said earlier, to be a sleeve that you slide your ID into instead. And as the chair has already mentioned, it's just not efficient. What you're asking for is for a person on the spectrum with another invisible ID disability to remember to pull out an additional piece of an additional item to show someone in the event that they are asked to present ID. It wasn't a racial ID. Race was not the impetus necessarily. It was the fact that my son has a disability, but he will be a Black man in America. And for that reason, to feel like some people who could have supported a bill that's voluntary, not support it was very frustrating. Again, I understand the idea that this may cause people to have a permanent record at the MVA. It may be possible, Mr. Chair, and senators, to have the bill amended to say that the MVA cannot keep a permanent record if a person is 18 and so chooses to remove this voluntary designation from their ID. But I do know that this bill is important. I know that the concerns that we as parents and that the individuals with invisible disabilities have expressed here today I hope does not fall on deaf ears. There are very valid reasons. I'm, again, so pleased to see support from the law enforcement community this year on this bill. And I truly do thank the chair. I thank Linda and Eric for their advocacy, because my son's not ready to be a self-advocate. He's 14, he's not ready to be a self-advocate yet, but he's doing his best. But I know that a bill like this, in a year and 9 months, when he's able to get his learner's permit, could have a huge impact on his interactions with law enforcement. So I do ask the committee for a favorable report. Thank you, Senator Charles.
I do want to say just one thing. I wanted to make sure that I know we've got more panelists coming up, but so look, we've got broad support, as you've heard, Congressman David Trone, Baltimore Ravens, University of Maryland President Darrell Pines, Sheriff, you've heard Max Wee, Prince George's County State's Attorney, Montgomery County State's Attorney, Montgomery County President, County Council President, and then the Sheriff of Prince George's County, John Carr. But also, look, this is my first year sponsoring the bill, and so I can't speak to the other years in the past and who has supported and who has not. I will say that every member of the advocacy or disability community has worked with me in good faith. So I can't speak to the past, but this year folks have worked in good faith and have supported with amendments, which, you know, some may be agreeable, some may not be, but I do want to put it on the record that everyone here has come forward with the same underlying goals for public safety and understanding some of those invisible disabilities and the difficulties that they pose for public safety and interactions with law enforcement. But I want to make sure that, just for the record, that, you know, Maryland Developmental Disabilities Council, the ARC of Maryland, have worked with me in good faith on this effort. We'll get there, but just want to make sure that at least at this iterative process, folks have been working in good faith and that it's been a pleasant experience. So.
And Martin Mitchell.
And Martin Mitchell.
Hi, thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Dee Sapp, and I am the chair of the Maryland Developmental Disabilities Council, executive director for 2 disability-related nonprofits, and the mother of 3 children, one of which is a 22-year-old male diagnosed with autism and an intellectual disability. I support the right for people with disabilities to live a life of dignity with as much independence as they deem necessary and possible. My son has his learner's permit and is in his 3rd year at a 4-year university in an accredited program designed for students with intellectual impairments. His life goals include being gainfully employed, having a family, and living independently. Obtaining his driver's license is an important and necessary next step in achieving his life goals, but as his mother, I have a great concern for his safety should he encounter law enforcement or a first responder untrained in interactions with people with invisible disabilities, because my son's first instinct would be to run. There are varying opinions about SB 1096 among people with developmental disabilities and their families. A deeply held belief within this community is that simply disclosing a disability doesn't ensure adequate protections or safety. My position is that I support SB 1096 only if the following amendments are made. Ensure the disability indication can be removed from a government-issued ID at any time. More mandatory training for law enforcement and first responders that is consistent across the entire state of Maryland. Establish and include very specific accountability measures of law enforcement and first responders should they be in violation of these mandatory procedures. And it is imperative that people with disabilities are included in the discussion about what labels are going to be used on the ID to describe the disability that's not offensive. I, along with the executive director of the Maryland Developmental Disabilities Council, also submitted written testimony with additional context to the proposed amendments. The fiscal impact of these amendments is minimal, and the safety of my son and others with invisible disabilities is highly reliant upon these additional safeguards under the law. Thank you for your time.
We'll hear for the rest of the panel, and then we'll stand by for questions. Yes, ma'am.
Good afternoon. I'm Yakisha Poole, founder of the Guardians for Change Group. I've been a public safety servant for 25 years, 21 of those years serving the state of Maryland in Prince George's County. I've submitted a letter in support of this law with amendments. To summarize, law enforcement officials and many other entities in our society depend on proper and effective IDs. We need them for proper service of legal documents, medical treatment, travel, and even to see our own children in our schools. Those that truly honor the badge want to protect and serve. Why not arm them with the power of knowledge so they can effectively assess a situation and provide the proper services to resolve a situation peacefully? Moving on to amendments, on page 3 of the bill, the six categories of non-apparent disability should include a 7th, health conditions, as it is already stated in the preceding definition. And can we clear up some gray areas? The categories, can we add terms, developmental disabilities or intellectual disabilities defined as, or mental health disabilities as defined in the DSM-5, which is the Diagnostic and Statistical Manual of Mental Disorders. In law enforcement, gray areas get you sued. Last, the notation of ND is not visually attractive. As a surveyor of an ID, I would be drawn to the vibrant A for autism, or the ear for hearing impaired, or any other specific symbols for invisible disabilities as proposed in Eric's ID law, because we need to assess the scene ASAP. I've been married to my husband for almost 4 years and just noticed he was an organ donor because the black block words are lost on our busy Maryland driver's license. Eric's ID law will give citizens who are unable and maybe a little afraid to speak up a voice. Eric's ID law gives Leos a chance to make a long-lasting positive impression on individuals with invisible disabilities. And Eric's ID law is a blessed step toward healing community and police relations. Thank you.
Great testimony. Questions from the committee? All right, seeing none, thank you both very much. We'll now switch to our panelists who are joining us virtually. We'll hear from we'll go with, actually, we'll go Mayor Cross. Welcome back.
Hello, thank you so much, Chairman, and to the distinguished panel and everyone who have joined together in arms to support Senate Bill 1096. I'm Mayor Kashina A. Cross of the City of Glenarden, and I'm so honored that this bill has come before the Senate as well as taken its next leg to address the concerns that are impacting those members of our community, precious members who have hidden disabilities. Many of us returning veterans, unfortunately, have faced the laurels of war and have found PTSD as a persistent resistance as it pertains to mental health and wellness. I am absolutely proud of Eric and all of his compadres there in that testimony room who have leveraged the complete responsibility to say, here I am an active part of the community, and I shall and need your help. I am honored by all the police forces who have stood in arms to make sure that everyone with a hidden disability as well returns and is a part of our community without fear. I am grateful for Miss Linda and how she shares the story of how when Mr. Floyd was unfortunately met with death on the streets, that Eric cried as he held his mom and he said, well, I am a functioning autistic. Many of my friends are not. I am grateful for the Senate, Senator Smith and Jackson, who have brought this bill, who heard the cry to return HB 121 to the table. It is time, with a favorable response, I ask, and with one amendment, that when license plates are ran, it also echoes the identification of someone with hidden disabilities, because not always will you get to the case of saying, I want your license, but if you run the plates, it will already tell you what the problem is before you address the situation. We need to be careful in that we make our citizens safe, we increase the ability for safety in our communities, and not only that, but we extend the arm of love for those who have hidden disabilities where God has chosen and they themselves have answered the call to be responsible in what they are having to bear as a hidden disability. I am grateful to this committee, and I am grateful to all the parents who fared the weathers in dangerous highways and byways to stand there in that room, and I see it filled now with love and compassion. So thank you for favorable support And I asked you for an amendment that includes it being put on the license plates. So when it is ran, we already know what the situation at hand is. Thank you so much.
Hey, thank you very much. Well, I'm looking over at Senator Muse. I thought today was Sunday, not Tuesday. I thought I was in church, not in the committee room. Appreciate that. All right. All right. We'll have Mr. Mitchell. You're up next. Welcome.
Yes, appreciate it. Greetings, Chairman and distinguished members of the committee. My name is Martin Mitchell. I'm here today to state my support of SB 1096 on behalf of the Prince George's County NAACP. 80% of people with disabilities have an invisible disability, one that cannot be readily seen because of using a visible assistive device such as a wheelchair, hearing aid, or other device. And I lifted that quote from Executive Director of the Invisible Disabilities Association, IDA, headquartered in Colorado. And so the simple notion that, adding this on an ID, it is inclusive, it's easy to recognize, and citizens with invisible disabilities. And there are similar states and countries that have passed similar laws. And so one of the things that I wanted to point out is it is not uncommon for someone with an invisible or hidden disability to be told, well, you look fine to me, or by someone in authority, which often results or could result in discrimination or even possible harm or death in intense situations. And so this notion can help de-escalate possible misunderstandings between law enforcement and first responders. And, one of my first jobs in college was working with Maryland National Park and Planning as a therapeutic recreation specialist at Vansville Elementary in Prince George's. And, I know firsthand that, disabilities, they come in many different shapes, sizes, and, some are not visible and some are non-apparent, but they should be respected. And, we would hate to have situations like Lamont Scott or Elijah McClain in our state. And so I urge this deliberative body to support this common sense bill called Eric's Law. Thank you.
Thank you very much. All right. Next, we'll hear from Mr. Zanfordino. Welcome. Hold on. I think you're still on mute. Let me ask if I can unmute you here. There you go.
All right. Thank you, Chair. Good afternoon, Sir Chair, and to the committee. My name is Tony Zanfordino. I am co-chair for the ARC of Maryland Government Affairs Committee. We are here to say we support this bill, but we are asking that you accept 3 friendly amendments. And these come from our discussions from previous bills that have been presented and also from talking to members of our committee. I am the father of a 17-year-old child with Down syndrome who has not yet learned to drive, but is strongly considering it. But our first amendment is adding requirements for police training and accountability. And we believe this can be done by making sure that the Ethan Saylor Alliance, which was created in 2015, has the proper funding and training for our officers who face great challenges on the street, but who are truly some of the most caring people you will ever meet if you've ever attended a Special Olympics event and to see the interaction between the officers and these athletes. So again, the first amendment would be to get some more police training and accountability. Second is to ensure that a person is able to remove that notation from the card and that it is wiped clean throughout the system of record at MVA. I'm not sure they have that capability at that time. However, they do have the blue card, which is already law and can be used as an attachment to their driver's license or any ID. The third thing is that that having this designation does not require a medical advisory board review. And the reason why we say that, because as you can imagine, a person gets stopped and all of a sudden they hand you their ID, and now all the law enforcement officers are saying, hey, well, maybe it's his disability that caused this. And, that's not something that should be attributed fair to their disability.
Excellent. Thank you very much, Mr. Your time's concluded. If you could just very briefly conclude.
Again, we have 3 amendments. The written testimony was uploaded, and we greatly appreciate your time.
Thank you very much. Thank you for joining us today. We have your written testimony. We'll definitely look at it. Thank you very much. Questions from the committee? All right, seeing none, thank you all very much. With that, that'll end the testimony and the hearing for Senate Bill 1096. Well, now I think Senator Kramer is here. We'll now move on to Senate Bill 872, Senator Kramer.
Mr. Chair, I believe there are a couple of folks coming in to join me for this. My long lost twin. All right, good afternoon, Mr. Chair, members of the committee. Ben Kramer here to introduce Senate Bill 872. Colleagues, this is a bill that should be a little bit familiar to you. It has been in the committee before. I am unaware that there's ever been any opposition to the bill, and I am hoping this is the year we get the bill across the finish line and improve the laws in our state to ensure that those who abuse animals or so extremely negligent with regard to animals that the animal either dies or needs to be euthanized. So right now, we have in statute an abuse or neglect of animal, and we also have in statute aggravated cruelty to animals. The problem is there's a gap in the law. Aggravated cruelty to animals, which does carry a very stiff sentence, requires that a person may not intentionally do certain harms to an animal. Intentionally. That's the operative word. In a case of negligence, it may not be possible to prove that the harm was done intentionally. The problem, though, is if it's simple negligence, there is a very small slap on the wrist, and that is not sufficient for when there are circumstances that the negligence was so egregious, so horrible, that the effect is the animal died, or it was determined when the animal was found and brought to a veterinarian that the animal had to be euthanized. Now, because of the work of this committee raising some questions last year about a veterinarian making this determination as to whether the animal needs to be euthanized, the language was revised to make it clear that there will be a second licensed veterinarian that concurs that the animal's health is so poor that the odds of being able to save the animal are such that it won't happen. It needs to be put down. So there's an enhanced penalty for someone who is so egregiously negligent that the animal had to be put down. And it also will afford the court the opportunity to do something very important. and that is to prohibit the defendant from owning, possessing, or residing with an animal for a period of time determined by the court. That's an important addition to our statute. Colleagues, this is not a frequent problem, but it does happen from time to time. I will share with you that there's a fairly recent case in the state where the dogs involved were kept in such terrible condition that they were found with severe injuries, in need of veterinary care that they never received, open wounds, open sores. These animals were in extreme pain. A couple of them did in fact have to be euthanized, and the other dogs that could be saved were in need of extensive veterinary care and services. So when we have these situations, it's important that we just have this tweak in our law to ensure that when it's appropriate, there is an appropriate sanction. With that, Mr. Chair, I'll turn it over to my panel.
So, hit the button or not? So good afternoon. I'm Jack Breckenridge. I'm a cruelty investigator for the Montgomery County Office of Animal Services. I want to thank Senator Kramer for his sponsorship of this bill and the committee for giving me an opportunity to testify in support of it. As an animal cruelty investigator for 22 years, I've witnessed many violations of 10604, particularly those involving neglect in the care of animals or animals that are found in deplorable condition. This bill strengthens the penalties when charging violations under 10604, where the conditions and treatment of the animal is so detrimental to an animal's well-being that it directly causes the death or euthanasia of one or more animals. I've investigated several cases of this nature, to include cases where an employee of a business has caused the death of an animal through neglect, such as a dog groomer leaving a dog tied to a table, causing it to choke to death, or a dog trainer that had basically worked a dog to the point of heat stroke. And both of these injuries were caused by the apathy and slothfulness of the suspects, because they were motivated by financial means instead of the welfare of the animals. At least 6 other states, including Virginia and Washington, D.C., have higher level penalties like proposed in this bill. And really the most important part of this bill is the prohibition on owning, residing, or possessing animals, because you take the cases where, like the dog trainer or the dog groomer that killed somebody else's dog, they need to be prohibited from possessing other people's animals for more than 3 years. So in both of those cases, they were both very specific financial gain. The groomer, because the faster she bathes dogs, she gets paid per dog, the more money she gets. And the dog trainer, same thing. And he was convicted at trial. So this would strengthen the penalties and also put in a safeguard for the animal. So I appreciate your time.
Good afternoon. I want to thank Senator Kramer for sponsoring the bill and the committee for giving me the opportunity to speak on its behalf. My name is Dr. Greg Lawrence. I've served as the Chief Veterinarian for the Office of Animal Services in Montgomery County since 2014. In my 20 years experience as a veterinarian, I've seen all manners of animal cruelty. SB 872 would amend 10604 to allow when violations of this section lead to the death or euthanasia of an animal in the most egregious cases to have the penalties be more in line with the result and the impact to the victim animal. Many of these cases don't rise to the level of aggravated cruelty, but the pain and suffering inflicted on these animal victims is just as severe. I've worked many starvation cases, for instance, in my 10 years at Montgomery County. And these cases suffer pain for a protracted period of time. And without intervention face, a very painful death with certainty. So even once we get a hold of them, getting them turned around is not as straightforward as just feeding them. It can be very challenging, and there are pitfalls with that. So there's no test for this. So it takes a lot of work to get in on these, and these animals suffer for months oftentimes. In other cases, failure to provide vet care. We've had cases where animals were so infested with fleas that they were anemic to the point of dying before we could get in there with a search warrant. Other animals that we took out of this particular case that I'm thinking of, one died a few days later, others were in life-threatening and needed emergency care. So I thank the committee for considering this bill, and thank you for your time.
Questions for the sponsor or his panel? All right, seeing no questions. Thank you, Senator Kramer, for bringing the bill. I appreciate all the testimony here today. That
Colleagues, let's get her done.
Senate Bill 872 is complete. Senator Augustine, I see you are here for Senate Bill 907.
Thank you, Vice Chair Wallstreicher, and members of the committee. Senator Malcolm Augustine here on behalf of Senate Bill 907, Motor Vehicles, Disability, Parking Placards, Photo Identification. Members of the committee, let me just share with you the genesis of this piece of legislation. In my district, we have a number of senior homes. And at these senior homes, these are senior living homes, though, where the folks are active. And but many of them are disabled, and many of them have disabled placards. And what happens is that in the parking lot, we may have 10 or 15 of these cars that are there, and everybody's got their placards out and everything else. And next thing you know, someone comes through, does a smash, and grabs smashes everybody's windows and grabs all these placards. And so because of that, and because I know that this has happened in other places, I went about trying to figure out, well, is there something we can do to prevent this from happening? Now, there are some ways, of course, that folks don't have to leave them up, and you can get a permanent one on your actual license plate. But in my research, I learned that 3 states had taken a different approach. In South Carolina, New Mexico, and Massachusetts, what they allowed was, or rather, they have a photograph of the person who has the placard actually on sort of the hang tag, and to make it less attractive to a thief, basically, so that a thief wouldn't necessarily see it as being as attractive. Now, I thought that was a good idea, but I was also then aware of, some concerns about making sure that there were privacy and things like that. And so I looked at Massachusetts, where they have a privacy sleeve that's on it so that people don't feel unsafe. But that if law enforcement, came, that you would have to show the placard for law enforcement. In other words, to make it so that you maintain the privacy, but then you are also making it a lot less attractive for these thieves to do these smash and grabs. And then as I thought about this as a process, not wanting to be overly burdensome to the MVA, Motor Vehicle Administration, I went and I talked to them about this, and came up with this concept, this idea of making it optional. And so that if there were these places where an individual felt like when they went in, that this was something that would make them feel more comfortable, that they would be able to do that, but that it wouldn't be a requirement, but that it would simply be an option that would be available to folks to be able to have this, to just hopefully make this smash and grab and this illicit market that we have for disabled placards a little less attractive and protect folks. There is some expense to it, is what you expect, like a printer, right? I mean, it makes sense, color printer. There would be a little bit of a delay in time for the person to receive it, but all of that to me makes sense if a person is able to feel a little bit more comfortable, a little bit more safe by virtue of having this placard that has a photo on it that can and will be protected. So that is the bill. And I would ask for a favorable report on Senate Bill 907 as presented.
Thank you, Mr. President Pro Tem. Senator McKay.
Thank you, Mr. Chairman. Thank you for bringing the bill, Senator. Does the bill speak to the size of these placards now that there being a photo on it? My only concern is the MVA already has an issue with things being hung on our rear view mirrors. Like you can't put the tassel from your.
Yep.
So my concern is have you addressed that issue about how big this thing is, what the sleeve would look like, and
in my conversations with the department, they indicated they had looked out into like what they had done in Massachusetts and that they felt like this was something that they could do. There would be a cost associated with it. That was the printer and stuff like that, but they did not express any concern about it being oversized. Like they would put, it's a matter of the size of the photograph more than anything else on the placard. And there is a printer that already does this because, these other jurisdictions are doing it.
Right. Okay. And then, is this too new that other places are doing it that shows data where smash and grabs have decreased?
It is not, it's not new. Some of these have had this. It's just been their policy for some period of time. I'll be happy to look into the incidences of smash and,
I'm just interested if I should get in the windshield bid.
Yeah, well, unfortunately, we're in the area where I represent, we're doing everything we can to prevent folks from having stuff in their cars because we do unfortunately see some smash and grabs.
I probably shouldn't announce. We just keep everything unlocked. So
okay, yeah, don't announce that. I don't do that. Yeah.
All right. Thank you very much, Senator.
Thank you.
All right.
All right. Thanks.
All right. With that will conclude the hearing for Senate Bill 907. Is that right?
Yeah, she's not here. She's not in.
Okay.
That's it.
That's it. So the mayor's not here?
No.
Okay. So, all right. No, she's gone. All right. Thank you very much, Senator. So with that'll conclude the hearing for Senate Bill 907. We'll now move on to Senator Mouts with Senate Bill 927. Senator Mouts, welcome.
Thank you, Chairman and colleagues. It's great to be with you. It's an honor to present Senate Bill 927. This bill was a result of a number of meetings we held over the summer in Dorchester County with Dorchester County Public Schools, local magistrates, law enforcement, focusing on juvenile justice. There wasn't really a consensus. There wasn't really an agreement on how to best move forward other than to try to supply information to state leaders to support the statewide movement on juvenile justice. So we came up with this one bill to focus on an issue in our schools. And that is to provide some sort of protection for teachers who are experiencing violence in schools. And Senate Bill 927 would add a second-degree assault to assault of a school employee or subcontractor as a crime of violence. This legislation is supported by the state's attorney for Dorchester County. There's a letter of support from the Cecil County government. There's also a letter of support or testimony and support by the Maryland Association of Boards of Education. There's some statistics that should be supplied to you in Dorchester County, in statistics for 2022 to 2023, that'd be last year, in Dorchester County, there were 633 student-on-student assaults, and there were 174 student-on-staff assaults. That's in Dorchester County alone. In Wacomico County, there was 1,391 student-on-student assaults, and in Wacomico County, in the same year, there was 265 student-on-staff assaults. That's 439 assaults on staff last year in Dorchester County. That's incorrect. That's 439 assaults on staff in Dorchester and Wacomico County last year. The purpose of the legislation isn't to create a criminal environment in our schools. It's the desire and intent of this legislation is to create some legal mechanism to draw a line on some of the violence that our school staff are experiencing within the school system. It's widely supported amongst teachers. We could have brought a lot of testimony, a lot of different episodes and things to try to support the legislation. I know this committee has debated quite a bit. You've heard a lot about this. We thought this would be a good faith proposal for you to consider, and we urge your favorable report. Thank you.
Excellent. Thank you very much, Senator. Questions from the committee? All right, seeing none, thank you very much. We'll now switch the opponents of the bill, and I think we have is Mr. Zacher here from the Office of Public Defender. Hey, welcome back. And then we have Alyssa Fio joining us virtually.
Thank you.
Good afternoon to the committee. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City. I work in our juvenile division. The Maryland Office of the Public Defender is asking for an unfavorable report on Senate Bill 927. This bill is very clearly designed to bring more 10 to 12-year-olds into our juvenile justice system, a system that is not really designed for 10 to 12-year-olds. 10 to 12-year-olds usually have a lot of competency issues. Services can be delayed while we work through our juvenile justice system. And you've heard testimony this session, and you'll hear from Ms. Fio later about why the 10 to 12-year-old age group should be dealt with in a different way. But this bill is written very broadly. It is not limited to just school environments. It elevates assault second degree to a crime of violence if the assault is committed on an employee or subcontractor of a public or private elementary or secondary school. The assault doesn't have to take place in a school or on school grounds. It could take place on a weekend when the employee or subcontractor is performing activities that have nothing to do with education. The bill also does not describe what a subcontractor is. So this has a very sort of a broad reach in terms of who the victims might be. And this is not a bill designed to address children. This bill is designed for everybody who may assault a school employee or subcontractor. So this bill can definitely affect adults simply because of the status of the victim, which the perpetrator may not even be aware of. So by way of example, if I have a school employee in Frederick County who takes a trip with their spouse to Ocean City and is lying on the beach and somebody kicks sand in their face, well, kicking sand in the face of the school employee is a crime of violence, but kicking sand in the face of their spouse isn't. That doesn't make any sense. We think this bill needs a lot of work if it were ever to be considered appropriate. We're asking for a favorable report. Thank you.
All right, Ms. Fio, welcome. You're up, and then we'll take questions at the end of your testimony.
Great, thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Alyssa Fio, and I'm an education attorney with the Maryland Office of the Public Defender. I'm testifying in opposition to SB 927 on behalf of the Public Defender's Office, as well as the Coalition to Reform School Discipline, otherwise known as CRSD. For over 10 years, CRSD has been advocating for Maryland to address the school-to-prison pipeline, which, as you know, constitutes a set of policies and practices that funnel students into the criminal justice system, which we know has dire long-term consequences for students. We're very concerned that Senate Bill 927 would only fuel the school-to-prison pipeline and would not improve school climate, or would it make schools safer for both staff and students. The school-to-prison pipeline starts with school discipline. At its peak in 2006, Maryland was suspending 9% of its school population. And last school year, it has been reduced to 4.9%. But with an arrest or a charge of a second-degree assault of a teacher comes an accompanying suspension or an expulsion. And because Maryland State Department of Education tracks both of those things, we know that both the arrest and the school suspension disproportionately impact students of color, Black students specifically, and students with disabilities. We are also very concerned that SB 927 would have a dire impact on students with disabilities. I've represented students with disabilities for 30 years who've engaged in physical behavior that is in fact related to their disability. And those students were either charged with assault or very well could have been charged with assault. But with appropriate supports and interventions, those students can be very successful. But when we look at the 2021-22 school-based arrest data, the data that I have is very different that we just heard. For example, Dorchester County is the highest suspending school system in the state. It suspends 17.5% of its population, which is very far off the average of 4.2. We therefore ask for an unfavorable report, and we think that there are many more effective ways to create safe and supportive school environments. Thank you.
Excellent. Thank you very much. Questions from the committee? All right, Sina, thank you both very much. With that, that'll conclude the opposition panel and the testimony and hearing for Senate Bill 927. We'll now move on to, is Senator Rosapep here? Yeah, there you are. Senate Bill 929.
Thank you. It's always a pleasure to be with you. And I want to start off by saying that this bill is not ready for prime time. But the problem is important, and the problem is ready to be dealt with in some way. Basically, what the bill does is it says instead of having only one place in a county where a sex offender can come in to check in, where they're supposed to check in under the sex offender registry law, there'll be multiple places to check in. That's what the bill does. Why did I introduce it? I introduced it because I have a constituent in Laurel who is a retired nurse, who is a saint, who helps every person who is having problems in the community. And she brought to my attention the case of a registered sex offender who is has many, many challenges from an income point of view, from a mobility point of view, from a health point of view. I could go on and on. And as she started to work with him, she found out, A, that he was a registered sex offender, and secondly, that he hadn't checked in years. And so she said, you know, you really ought to check in. He said, yeah, but I got no transportation. There's one place in Prince George's County we can check in. So she started working out to give him rides and stuff like that. But she said, she came to me and said, this is a ridiculous system. If it's valuable to have folks on the sex registry check in, we need to make it easy to check in, not hard to check in. And so what I came up with, I talked with several members of this committee, several members of the House to say, what do you know about this? Because I didn't know much about it. And so I came up with this bill to basically say that you'd have to have multiple places to check in. They have testimony from the Police Chiefs Association saying that'd be a huge burden on the smaller forces. And they propose amendments to say only 2 places in a county with at least 500,000 people. Well, Prince George's County, having 2 places in Prince George's County doesn't make it convenient. And you know your own areas. So I urge the committee to think about this. One of the things I learned along the way from talking to police, and I don't know whether this is widespread, but it's certainly the conventional wisdom I picked up, is these check-in requirements aren't very much enforced. And they're warrants, but it's a low priority. And so I'm not even sure the system is actually working the way it's intended to work, but this committee would know better than I do. But if it makes sense, it ought to work. And if it doesn't make sense, it ought to be changed. So with that, I say, if you don't pass the bill immediately, I'll understand. But I would hope that you all knowing more about this than I do, or if there are the ways we can help you in the budget committee to figure out a way to make this system work. Thank you, Mr. Chairman.
Excellent. Thank you very much, Senator. Questions? Senator McKay has got a question.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this bill. as I read this in the fiscal, it says sex offender has to register every 6 months.
It varies by what category you're in. There's a
Is that
1,
what
a
it
2, or
is?
3. There's 6 months a year. There's 3 months.
What is the smallest? 3 months?
I think 3 months is the smallest. Yeah, is the shortest.
Okay. All right, thank you.
Yeah, thank you.
All right, seeing no further questions, thank you very much, Senator.
Thanks an awful lot.
Thank you. All right, and then that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we have Chief Morris. Welcome.
Good afternoon, Mr. Chairman, members of the committee, Chief Dave Morris, Chevrolet Police Department, representing the Maryland Chiefs and Sheriffs Association in opposition to the bill. It's glad to hear the senator say that it's not quite ready for prime time yet, and we appreciate that. I've got about 2 minutes to explain what I've come to discover is probably one of the most complicated, complex, time-consuming processes, having spent hours speaking with investigators around the state as to what it takes to actually do these registrations and conduct these registrations with regards to the convicted sex offenders. So this isn't just a matter of getting a name and an address. This is a matter of victim information, conviction information, professional licensing, reviewing all the social media that is associated with these individuals that are convicted of these very serious crimes, as well as fingerprinting, DNA sampling, and all of this associated process. So it's extremely time consuming. It's a very specialized area within the law enforcement community. So I won't spend a lot of time. The fiscal note as it relates to this, you have it in your packet, for one county on the Eastern Shore is over $650,000 just for the structure, and well over $900,000 for the first year of implementation. In conversation with a colleague from mine from Prince George's County Police Department, they would be talking millions of dollars in order to implement this. And not judging, just making a point. These are the individuals that we're talking about. These are individuals that are convicted of crimes of sexual solicitation of minors, sale of minors, human trafficking, marriage trafficking, hiring of minors for prohibited purposes, running houses of prostitution. These are very serious offenses, and probably most important is if we miss something in this, as it relates to these individuals in the registry process, there's a significant consequence. I'll end very quickly by saying that the House has a similar bill, not the same bill, and we're working with the delegate as we'll work with the senator on some amendments that may get us over the hurdle. So I'm available for questions. Thank you.
All right, thank you very much, Chief. Questions from the committee? All right, see you none. Thank you.
Thanks, Senator.
Good to see you. Go Navy.
Yes, sir.
There you go. All right. All right, with that, that'll conclude the hearing for Senate Bill 929. Is Senator Woolstreich up next?
Is another one of the hearings, so do you want to skip over and go to Senator West?
Okay, Senator West, are you ready to go? Senate Bill 1036, Senator West.
Thank you, Mr. Chair and members of the committee. It's a pleasure to be here to present Senate Bill 1036. This bill came about a couple of years ago. You may recall I was able to get the Juvenile Restoration Act passed. And it was a quite memorable evening when I had to stand up on the floor of the Senate and oppose my governor's veto of the bill. So that it stands out in my mind quite strikingly. The following fall, or maybe it's the fall after that, I was invited to a forum at the University of Maryland Law School in which the results of the Juvenile Restoration Act were going to be discussed. And there were a number of people who had been released who were there that evening. And I was sitting next to Delegate Jazz Lewis, and some of the people who were released spoke to us and said the worst thing about the whole experience was they were simply dropped off on a street corner with nothing more than the clothes on their back. And they had no ability to, they had no money, they had no place to go, they had no transportation, they had no job, they had no place to spend the night. And I turned to Delegate Lewis and said, my goodness, is that all we do for people getting out of jail? We need to do something about this. And he said, yes, we do. So that was the inspiration of this bill. Not being an expert in this area, obviously, the way that I proceed would be to do a study to try to find out what's going on, what's happening, what are we doing right, what are we doing wrong? It sounds like we're doing a lot wrong. And then what should we do to try to fix the problem? So by now, an acute observer might have noticed a recurring theme with my bills this session: the preemption of criminality and the prevention of repeat offenses. And this bill falls into the latter category. This bill establishes a task force on the creation of a division of returning citizens and expanded reentry services to focus on state prisoners who are scheduled to be released from prison or who have recently been released from prison. The task force will be responsible for assessing measures of reentry success, coordinating existing department and community reentry programs, removing barriers to reentry, and connecting incarcerated individuals with both pre- and post-release assistance. More specifically, the task force will identify and assess the current reentry services that exist in the state, including gaps that currently exist, assess the markers of successful reentry, and develop a plan to establish a permanent division of returning citizens within the Department of Public Safety and Correctional Services. The task force will also establish a plan to expand housing, transportation, employment, social services, healthcare, education, and legal services to individuals who've just been released from incarceration. The housing plan will render necessary assistance in finding halfway houses, family homes, or apartments for released prisoners. The employment plan will render necessary assistance in finding employment for released prisoners, including assistance in obtaining vital documents and in preparing resumes. And the health services plan will render necessary assistance in finding healthcare providers, mental health providers, substance use counseling, and the like. Finally, the education plan will render assistance in connecting to GED programs and post-secondary education as needed. The bill gives the task force 18 months to complete its work, requiring its work to be submitted by December 2025. In conclusion, it's simply intuitive that it's counterproductive to both justice and the public safety of the state if we don't give released prisoners the tools they need to maximize their chances of succeeding once they're no longer behind bars. This is the best way to prevent recidivism. I'm looking at Senator McKay over there, who has put these sorts of practices into play in his part of the state for many years and done an incredible service for the citizens of Allegheny and Garrett counties in this regard. Seems to me we need to recruit people like Senator McKay across the state to help prisoners who've gotten out of jail. And we need to get prisoners into a position where they're able to resume a role as a law-abiding citizen and a productive member of society. I recommend this bill to you, hope for a favorable report. And I think there are a couple of people who want to testify in favor, who had signed up to testify. If they're here, I defer to them, and then we can all take questions.
Excellent. Thank you very much. We'll have Ariana Evans and Rita Gray. And then we have Ms. Cross joining us virtually.
Oh, hi, sorry. Good afternoon, Chair Smith and Vice Chair Waldstreicher and honorable members of the Judicial Proceedings Committee, excuse me. My name is Afeni Evans, and I'm here to address you today on behalf of Life After Release, an organization dedicated to supporting formerly incarcerated individuals as they navigate the challenges of reentry. As an organizer who works solely on and closely with this community, I'm compelled to express our resounding support for Senate Bill 1036, a crucial piece of legislation that holds the promise of transforming countless lives across our state. Throughout our work at Life After Release, we witness firsthand the barriers that returning citizens face as they seek to rebuild their lives and reintegrate into society, from the lack of affordable housing to stable employment opportunities, and to the pervasive stigma and discrimination that follows individuals with a criminal record. The obstacles can seem overwhelming and insurmountable. Senate Bill 1036 represents a significant step forward in addressing these systemic challenges and advancing justice and equity for all formerly incarcerated individuals by establishing a task force to examine the root causes of recidivism and develop strategies for reentry support. This legislation signals a commitment to fostering a more inclusive and supportive environment for those seeking to turn their lives around. We are particularly encouraged by the provision in Senate Bill 1036 that says that the task force will have to present a report to the General Assembly in 2025 on the establishment of division of returning citizens within the Department of Public Safety and Correctional Services. Division has the potential to serve as a central hub for coordinating resources, providing essential services, and advocating for policies that promote successful reintegration. In conclusion, I urge all members of this committee to stand in solidarity with formerly incarcerated individuals by supporting Senate Bill 1036, by investing in reentry services and dismantling the barriers that prevent individuals from accessing the support and opportunities they need to thrive. We can create a more just and compassionate society for all. Thank you guys so much.
Good afternoon, everyone. Chair Smith, Vice Chair Wallstricker, and honorable members Stryker, and honorable members of the Maryland General Assembly. My name is Rita Gray, and I come before you today as a formerly incarcerated individual who understands firsthand the challenges of reentering society after serving time. It is with great hope and gratitude that I express my unwavering support for Senate Bill 1036. A bill that aims to establish a task force dedicated to addressing the barriers faced by individuals like myself as we strive to rebuild our lives. As someone who has experienced the difficulties of reintegration, I can attest to the myriad obstacles that returning citizens encounter on a daily basis, from securing stable housing and employment to navigate the complex web of legal restrictions and social stigmas. The journey to successful reentry is fraught with challenges that can often feel insurmountable. Senate Bill 1036 represents a beacon of hope for individuals like myself who are seeking a second chance by establishing a task force to dive deeply into the root cause of recidivism and identifying tangible solutions. This legislation demonstrates a commitment to providing meaningful support to those who have paid their debt to society. One aspect of Senate Bill 1037 that particularly resonates with me is the provision to establish a division of returning citizens within the Department of Public Safety and Correctional Services. This division has a potential to serve as a lifeline for individuals like myself, providing access to vital resources, support services, and opportunities for rehabilitation and growth. In closing, I urge all members of the Maryland General Assembly to stand in solidarity with formerly incarcerated individuals by supporting Senate Bill 1036 by investing into reentry services and breaking down the barriers that prevent us from successfully reiterating into society. We can create a more just and compassionate system of justice that recognizes the inherent dignity and worth of every individual. Thank you for your attention on this crucial issue.
Thank you very much, Ms. Gray. We'll with the mayor. Is the mayor in? Here we go. Mayor Cross, then we'll take questions after that.
Hello, sir. I am here. Thank you so much, Mr. Chairman, and thank you so much for bringing Senate Bill 1036 to the table. As a mayor of a city, it is important that we understand that about $2 billion is lost if we look across the state of Maryland for those returning citizens who haven't learned how to reintegrate properly into our community and into society. I am an advocate for a task force who will focus predominantly on not only the jobs, but the equity with bringing our returning citizens back stronger with dignity and with respect into the community so that they can become returned citizens. That word citizen gives you ownership as well as residency, gives you the priority and the responsibility of civility in our communities. It's so critical that we return our citizens back strong. 1036 gives us a task force who will do a deep dive into looking at what those opportunities are, what those residual mental health and wellness conditions were, and start to heal our community and build the strength of our community by networking and involving the people who have found themselves on the other side of the law, have right-sized themselves with society, and we are now required to return stronger. We are better together, and I thank you for supporting Senate Bill 1036, sir.
Great, thank you very much. Questions for the committee? All right. With that, thank you all very much for your testimony. Thank you all.
By the way, let me just add, If this bill passes, I'm happy to be appointed as one of the senators to sit on the
Well,
committee.
that's the rule. You create a task force, you gotta sit on it.
I know.
Yeah. All right.
Thank you guys so much.
Thank you all very much. Thank you both. All right, with that, that'll end the hearing for Senate Bill 1036. We'll now move on. Senator James, are you ready to go? Excellent. Sure. It's Senator James with Senate Bill 107.
Mr. Chairman, I do not know if I have a panel. I do. All right. Is it okay if the panel just comes up out to the table? Thank you.
Want me to call the rest of them up on
Yeah.
the, okay.
Yeah, I don't know if they're outside or.
It's Andrea Mansfield's, Paul Ellington, and then Bob Benton, but.
I
obviously
know it's late in the day.
Something like
I just don't want to give them short shrift if they did want to testify. I think my friend from Prince George's County probably find it rather ironic that I have a towing bill, but since I, have a lot of concerns about late night towing. But honestly, when I was approached to take a look at this legislation, I would have told you, oh, the law is very clear, must be in statute somewhere. You don't get your car back until you pay, the towing company. But believe it or not, it's not crystal clear, I think, and that's why this bill is here. So Senate Bill 107 would create a possessory lien and statute on motor vehicles that are lawfully towed from a private parking lot pursuant to a contract between a towing company and the lot owner. While DLS, suggested and had us with this bill amend the laws governing statutory liens, which are in commercial law article Title 10-16101. I think this bill is also really aimed at clarifying Title 21, Subtitle 10A, which is really governs the towing and removal of vehicles from lots, and is really the gold standard by which every county then looks to the state statute on how you can enact a local towing law, making sure you give a lot of notice, good signage, don't take the car too far away, give an opportunity to get the car back after paying fees. And obviously, even if you're not paying fees, have access to the vehicle, get any personal property out. But apparently it's not crystal clear. I could only find one Maryland case, which is, we just want to put it on the record. It's from 1990. It was a Court of Special Appeals, Glenn Cade, GG Towing et al. Versus Montgomery County. And it did uphold the constitutionality of a local towing law that just followed what the state law is in Article 21. But the court said, we can't reach the issue of whether you have a possessory lien or not, because it wasn't preserved on appeal, but let us say what we can, which is there absolutely is an implied agreement between the owner of the vehicle and the towing company that you have to pay those fees before you can get the car back. But it's not in a possessory lien position, which is important to dispel any confusion and not have people keep litigating this issue over and over. So I think it's time for the legislature to weigh in, decide whether this is the right course to take. And when I started doing research, this is the modern era. Every state I looked at had a possessory lien in statute for towing companies and a lot of other things for that matter. But I listed the states, some of the states that I could find. Idaho, Illinois, Florida, North Carolina, Pennsylvania, Colorado, Delaware, and I think the list goes on and on. I want to just end with this. There is an issue of whether this statute should be retroactive. I will be honest, I did not see that provision in the bill. And that's not what I remember asking for. So I'm open to the discussion about that. I think the advocates would like it to be retroactive, but I'm open to however that, what the committee's pleasure is. And the bankers, I met with their representative, we all know Bob Etten. The bankers rightfully have an amendment that clarifies that this possessory lien would be subordinate to securitized car loans. And I just don't want to complicate this too much, but when you go and look at the statute that deals with statutory liens, you're going to see that we already give a lien to mechanics who repair vehicles. We already give it to storage companies that are storing these vehicles. Really, the towing company is just saying, we just want that same clarity. We want everyone to understand when we take your vehicle, we can hold it until you pay the bill. And that's the end of that testimony. And I would hope you would rule favorable. And I hope we have some experts who can go into this in a little more detail. I thought you'd find that ironic.
And good afternoon, Mr. Chair, honorable members of the committee, and thank you, Senator James, for bringing this to the attention of the Judicial Proceedings Committee. I'm Thomas Tomstead on behalf of Henry Wrecker's Service in full support of this legislation. I too believe that this was settled law because every experience I've had with a tow involved me paying to get the vehicle back. And then when we dove into the law, we saw there was kind of an inconsistency that was going on, because if you look at the transportation article, and Senator James was correct, 2110A, specifically 05, talks about how a tower must give the owner of the vehicle an opportunity to come into the lot and inspect the vehicle at any time, as well as retrieve any items from the vehicle that's not attached to it. So I think when we drafted these laws, we envisioned that the tower would actually hold the vehicle until payment was made. Because if they could simply just walk in and take the vehicle without paying, we wouldn't need provisions like that in our law. Unfortunately, the only case we have is the Cade case from the 90s. And that case in the 90s indicated that, yes, there is an implied duty to pay. When you drive onto a private property, you look at a sign and that sign says, hey, if you park here, you run the risk of being towed and this is where your vehicle will be. You've impliedly consented to paying for that tow. We're simply saying that the only way to leverage the payment in this situation is to afford the tower the ability to hold the vehicle. We agree with the amendment that the bankers will offer. I've spoken to Mr. Enton as recently as this afternoon. We don't want title to the vehicle. We don't want any interest in the vehicle but possessory. We would simply be last in line in priority for any lien. I do think the retroactive provision, whether that remains or not, simply was the most expedient way to recognize, since towing of the Model T back whenever that rolled off the line, that the industry practice has always been that when you go to a tow lot to reclaim your vehicle, you have to pay the tow fee. That is the only reason that is in there, and I ask this committee for a favorable report.
All right, thank you very much. Questions from the committee? All right, with that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Is Richard Gordon here?
Yeah.
There we go. Marceline White.
Ms. White is in a hearing in ECM.
Got it.
She apologizes.
Okay, no worries. And then we have a couple of folks joining us virtually, but we'll start off with you. Mr. Gordon, welcome.
Thank you very much. Thank you, Mr. Chairman and members of the committee. My name is Richard Gordon, and I am a private court. 33,500 Maryland consumers, most of whom are from Montgomery County, whose vehicles were towed by Henry's Wrecker Service between 2019 and 2023. In each and every instance, Henry's Wrecker Service asserted a possessory lien over those vehicles. We, by the way, firmly believe that the law is fully settled in this area and that there is no ambiguity whatsoever. I thought it would be helpful to tell the committee a little bit about the named plaintiff in our case. Sharnice Hall, who 3 years ago in March 2021, while visiting her elderly mother to take her to a doctor's appointment in Montgomery County, had to stay the night with her mother. She followed all the rules. She went down to the apartment building. She got a copy of the rules. She went to the front desk. She registered her car. She got a parking permit. and she was told to put the parking permit up on the dashboard of the car. She did that. She parked her car at 3 a.m. Henry's Wrecker Service patrolled the parking lot. They took her car from her. They towed it away. And when she went to pick it up, they asserted a possessory lien. They told her she wouldn't get it back unless she paid all the money. And unfortunately, she had to do that. Her only recourse was to file this lawsuit. This is a very problematic issue, primarily because this legislation will interfere with an ongoing piece of litigation in federal court. And time again, the Maryland courts have said that retroactive legislation is unconstitutional. Now, I've also submitted written testimony that goes into a little bit more depth. We do ask that you give the legislation an unfavorable report. And thank you, and I'd be glad to answer any questions.
Thank you very much. Well, let's take the two virtual panelists first, and then we'll take questions. We'll hear from Mr. Holland. Good to see you. You're up.
Thank you. Good to be here, Senator. So this bill as drafted, like I said in my written testimony, it says under Title 21. The word under, I mean, we don't know what that means. Does that mean someone who otherwise complies or doesn't comply with Title 21 has an issue? The problem is it's just vague, and it's going to create litigation over what that means. And is it going to give a pass to someone who otherwise is not in full compliance with it? That's kind of as drafted. But the bigger issue is following up on the testimony I just heard. I mean, this body is not in the business of drafting retroactive legislation to eliminate a pending lawsuit. We don't do things by legislative fiat here. It probably most likely would be declared unconstitutional by the Maryland Supreme Court anyway. But I just don't think that it's right that this body would be used to try to eliminate an existing lawsuit over, something that's already going on. I don't have anything else to say unless there's any questions.
Excellent. Thank you very much, Mr. Holland. Is Eric Friedman here?
Yep.
All right, Mr. Friedman, welcome. You're up.
Thank you, Chair Smith, Vice Chair Wiltshire, and committee members for the opportunity to share what will happen to consumers in our office if this bill is enacted. My name is Eric Friedman. I'm the director of the Montgomery County Government Office of Consumer Protection. Been working there for 4 decades. Our office licenses new home towing firms. We set the rates for non-consensual towing, and we investigate disputes and illegal towing activity. State of Maryland, of course, has similar laws. Baltimore City does as well. These are complicated rules and procedures that require information regarding signage requirements, safety issues, and police notification. Non-consensual towing is a unique consumer transaction unlike anything else in the marketplace. Typically, if a merchant has not been paid, they go to a collection agency, or they file in small claims court, or they give the consumer an invoice. The ability of our office to appropriately investigate disputes and maintain a balance in our marketplace between the property owners and drivers would be significantly impaired if this bill is enacted. Unfortunately, non-consensual towing is subjected to predatory practices where towers act as the judge, jury, and jailer. They preempt our ability to do our investigation and keep the balance that we need in the marketplace. These complaints and problems have gone to a crisis limit where they've been the subject of local and national network news media. If this committee establishes a mechanics lien for these merchants, we will not be able to properly ensure integrity in our marketplace. We respectfully request that the committee give the bill an unfavorable report. Please refer to our written testimony, and please feel free to contact our office if we can provide any additional information. Thank you.
Excellent. Thank you both very much. All right, questions on the committee? Okay, Senator McKay.
Sir, please. Thank you for your testimony. So I'm a little confused. So you got mechanic liens and all these other different liens.
Mhm.
And so why should the towing not be able to get its fee through a lien?
We're not suggesting that the towing company shouldn't get its fee. And I believe the case that was referred to, which is Cade, does say that there's entitlement to be paid. We're not suggesting there is no entitlement to be paid. The question is, do they have the ability to take the car? It's modern day piracy, to take the car of someone who they didn't contract with. They have the contract of the towing company is with the private parking lot owner. This is an individual. These are individuals who drove their car onto a parking lot, and for whatever reason, whether it was predatory or it was justified, the vehicle was towed. But it takes away the ability of the individual to challenge what happened. And in many instances, these tows are predatory. Henry's Wrecker Service is just one example of a company that engaged in massive predatory towing throughout Montgomery County. 33,500 vehicles were towed over 4 years, where a possessory lien was enforced every single time. And the law, by the way, is clear. There isn't just the Cade case out there. There's a 1988 Maryland Attorney General's opinion that says that there is no possessory lien. There's also another case out of the Maryland Court of Special Appeals, which is TR versus Lee, which is also crystal clear that there is no lien on a vehicle. Now, specifically, why should towing companies get a lien? I don't know why they would be entitled to a lien than any other merchant who is selling goods or services. The reality is that if you go to a mechanic and you have them do work on your car, you as an individual are asking for that work to be done. And therefore, the mechanic's lien makes perfect sense. But in this instance, no one is asking for their vehicle to be towed. And it takes away their options and their ability to challenge in the future whether or not the tow was viable and also justified. And the last thing I would say, if you just permit me one more comment, this also disproportionately affects the poor. Many people go and they don't have the money to pay the towing fee to get it back, but they could pay it in the future if they're just sent a bill like any other merchant would do. So individuals have lost their jobs as a result of having their vehicle towed. They've lost the possessions in the vehicle. And ultimately, if they can't pay the towing fee, the towing company takes the vehicle and sells it. And they sell it for a very small amount, and the vehicle is lost to them entirely. So it is something that has very significant impact on the poor and the working poor especially. They need the vehicles to drive to work, and in many instances, they're denied that ability.
And I appreciate your testimony, but that doesn't take in consideration that they were parking where they shouldn't have been parking.
In some instances.
Right. So you're saying through your testimony that they have no recourse whatsoever.
They do. Like any other company, they can send a notice saying you owe the money. They can file a lawsuit. Debt collectors, for example, have two options. They can either get a voluntary settlement from someone, or they can go get a judgment in court. That's why we have the court system. There's no reason why a towing company that is often engaged in predatory behavior should be permitted to have a step up above everybody else, because they would be ransoming the car back to the individual.
Okay, but I hear that. I think you're throwing out the whole baby with the bathwater with a wide brush, saying all of the towing companies are predatory. I think that is incorrect. I do hear you've got a particular good example of somebody who obviously has, through your examples, have done that, but to take a brush and throw all of the towing companies in to say that they're predatory for having an agreement with a parking lot for people who are clearly marked that they're not supposed to be parking there, and then say that they don't have any form of responsibility other than through a collection agency to actually get their money is unfortunate. So thank you.
Well, I'm not saying, Senator, that every towing company is predatory. What I am saying is that
you did say that.
No, what I said was that there are many instances where they are engaging in predatory behavior.
And you've said that many times to set the record that towing companies are predatory. That was your testimony. Thank you, sir.
Thank you.
I have a question and then a point of personal privilege. I just want to follow your logic. Is it your position that the statutes that we have on the books now, that basically whatever they say, if somebody comes to ask for their car from a towing company, the way you read the law now, the towing company returns it to them regardless of whether they pay?
That is correct.
Okay, that's fine. And now the point of personal privilege. I just read some of, I don't know, are you from the Holland law firm?
No, that's Mr. Holland who's on.
Well, to the extent anybody said that this bill was put in to interfere with litigation, that's simply not true. I was not aware of any litigation. And if anybody listened to my testimony, I said I didn't realize there was a retroactivity. And unfortunately, I cannot amend a bill until I get to committee. So I made it perfectly clear what my position was on that error, which I think has stirred up a hornet's nest in this situation. So I just want to clear up those two things. Thank you, Mr. Chair.
No, thank you very much, Senator, for the clarification. Fair point. Further questions from the committee? Thank you very much. Thank you.
Thank you.
All right, with that, that will conclude the testimony and the hearing for Senate Bill 107. We'll now move on to Senator Carter with Senate Bill. Which one do you want to take? 894? Senate Bill 894.
Good afternoon, Mr. Chairman and committee members. Extra credit to all of you that are still here that don't have a bill to present right now. Thank you. So listen, we are back. Baltimore City back once again, asking for the final step for local control of our Baltimore City Police Department. Now, some of you, I see that quizzical look on Senator West's face. Why are you still here? Well, because in 2021, yes, we passed a law putting out for referendum the local control of the Baltimore City Police Department. And that was passed by a large percentage of the voters, close to 85% of voters voted for that. But there's still a clause in our law that has prohibited us from having full control. And so all this bill does, if you look at the very simple language, is it strikes out the part of the law that hinders us from having full legislative control over our department. I'm going to be brief because it's late and we have a dinner to go to later on for a rare dinner. But also I'm happy to be joined by Councilman Mark Conway and Hannah Zinker. Say that right. And for the record, its bill is, of course, a Baltimore City bill supported by Baltimore City Mayor and City Council of Baltimore, as well as about 85% of our residents. And there's a plethora of written testimony and support, as you can see. Thank you very much.
Thank you, Chair Smith, and thank you, Senator Carter, for introducing this bill. I'm here. My name is Mark Conway. I'm the Chair of Public Safety on the Baltimore City Council, representing the 4th District. Here in strong support for Senate Bill 894, control over powers of the police commissioner. Senator Carter already alliterated the long history on this bill. I won't belabor exactly those issues. I'm happy to say that we are here in partnership. We are all on the same page. This question is largely solved, but still technically in limbo on our books. Simply what this bill does is strikes a very specific line in Article 2 of the Baltimore City Charter and in state law that prohibits the city council from writing laws on the police department. I want to be perfectly clear. The police department is a Baltimore City agency. The state does not have ability to write laws on the Baltimore Police Department today. So what this does is literally just changes, or excuse me, clarifies the responsibility, the legislative responsibility for the police department in Baltimore City. I want to thank the Local Control Advisory Board, advocates, and the administration for all the work that they've done to get us where we are today. We have to date passed 2 bills, one that will authorize a charter charter amendment to delineate the responsibilities of the police commissioner. So we're all here. This is a pretty straightforward bill, and I'm looking forward to getting this done. I urge your strong support. Thank you.
My name is Hannah Zinker, and I'm a resident of District 46 in Baltimore City. On behalf of Jews United for Justice, a member of the Campaign for Justice, Safety, and Jobs, some of whose members are here with us today, I'm submitting this testimony in support of SB 894. In our democracy, the will of the people and their ability to take action is our greatest strength. And the people of Baltimore City have spoken. In 2022, over 82% of Baltimoreans voted to make the Baltimore Police Department a city agency to restore power to the people through local control. However, to codify local control, the Maryland General Assembly must remove a minor provision in the Baltimore City Charter that prohibits Baltimore from having control over the BPD. Baltimore City is the only locality in Maryland with limited control over its own police department. Because of this, Baltimore City is unable to meaningfully enforce police accountability or reform measures that would benefit both residents and officers. Other jurisdictions may use their local control to take safety measures like requiring the use of body-worn cameras or collecting data on use of force incidents. Such steps keep police departments accountable and allow officials to make changes that best suit their communities. As Ray Kelly, Executive Director of the Citizens Policing Project and tireless advocate for restoring local control, has said many times, accountability starts with access. Baltimoreans have demanded, fought for, and won the right to that access, but still do not have it after over 150 years. This is a racially unjust and insulting policy, signaling to the majority of Black residents of Baltimore and their officials that they are not trusted to govern themselves. If Baltimore establishes local control over their police department, community members and officers could build a more just, more effective, more trustworthy BPD. Until this happens, Baltimoreans have no hope for transparency and accountability in their city's policing. I respectfully urge this committee to make this hope a reality and return a favorable report on SB 894. Thank you.
Excellent. Thank you all very much. Questions from the committee? Well, well, Senator Carter, thank you very much for bringing the bill. And thank you both the witnesses. Thank you, Council member. There in 2000, maybe you can help me remember this because I think it's important for all the committee members to have access to this. When we went through police reform, there was a report on the history of the Baltimore City Police Department. It was like the best, 25 pages on, it was a lengthy history of this. And it gave the through line all the way from before the Civil War and really the importance of making sure that the city has control of their police department. And so I'm very supportive of the bill, but I do think we should, I'm going to find that report. It's great reading. It's great history that I think everyone should have, even though, we don't represent the city. So Senator Carter, Councilmember, thank you very much. Ms. Zinker as well. Thank you all for your testimony. Seeing no questions, we're going to keep the train moving. Thank you all very much. Thanks for hanging in there with us.
Thank you very much. I urge a favorable report, of course. And then, it'll make many of you happy. We get this done and you will not have to hear about these issues in our police department anymore.
Yeah, all right. Well, just for the record, that ends Senate Bill 894. We'll go on Senator Carter, Senate Bill 1030.
Oh, thank you so much. This next bill is one of the finest bills ever, and I'll explain why shortly. Senate Bill 1030. I'm asking for two witnesses, Derek Liggins and Judge Karen Friedman, who are both here. Please have a seat. So, committee members, Mr. Chairman, you did hear this bill once before last year. I brought this bill last year. I reviewed the bill hearing testimony. It was a fantastic presentation, if I say so myself. I felt that I made a very strong case for why good cause expungement is the best way that we can proceed with our continued evolution on expungement laws. We have evolved over the last 20 years from the efforts to expunge non-convictions to now allowing certain convictions to be expunged. We allow misdemeanor convictions to be expunged. We allow certain non-violent felonies to be expunged. And we put timeframes on that. We say once a sentence is completed, fully completed, 7 years, 10 years, 15 years. For the most part, many of these crimes can be expunged from people's records. I do not need to explain to this committee why this is important. why people need to overcome the taint of criminality, why it's important for full citizenship to be restored, so they can have educational opportunities, employment opportunities, housing opportunities, and frankly, it's really an issue of human dignity. That once you have paid your debt to society, you are free to once again reclaim full citizenship and be treated equally and the same as everybody else in the society. You should not have to constantly be barred and having impediments to full citizenship because of that criminal record. And so that is the reason that good cause expungement makes so much sense. Even with all the laws that we've passed, we still have people that fall into holes and gaps and are not able to get their records expunged, everything from some minor traffic offenses all the way to the more serious offenses. All the bill does is give it to the court. Let a judge decide if the individual standing before them has adequately shown that they deserve to overcome their conviction and have their record expunged. The bill lays out very clearly what the considerations of the court would be. And so the court would articulate the reasons for finding need for a good cause expungement. And, you know, I've had many occasions to be in court, and I've witnessed hearings where people have applied petition for expungement. And in those cases where it's not a slam dunk, it's not guaranteed, they're often granted a hearing. The state sometimes opposes it. And the court, I've heard many times, and I'm sure Judge Friedman can probably attest to this, I really wish I could do this, but the statute doesn't allow it. And so I want us to overcome any possible statutory barriers and just let the decision rest with the court. There are few, if any, judges in this state that are going to take a risk, a political risk of offering expungement to someone that does not deserve it. In fact, the person that is going to be granted a good cause expungement probably deserves it 10 times over before a judge would be so not lack the caution to offer an expungement to someone who doesn't deserve it. So for all of those reasons, this is truly the way we need to proceed. We need to stop with the cookie cutter approaches, this one and that one, and this sentence and that sentence, and this amount of time and that amount of time. It doesn't assess anything about whether the individual has done anything to show that they actually warrant and deserve an expungement. But someone that's been working under the table for 8 years doing HVAC, but they cannot get a legitimate job because of the felony conviction that's not expungible. That is the type of person the court should be able to look at and assess. And so I really, really urge this committee to take this bill seriously and to offer a favorable report, because it is my true belief that with all of the progress that we've made, until we pass this law, we are still not offering people an opportunity to properly re-enter society and be full citizens once they've paid their debt. And with that, I will be quiet and happy to answer any questions. Thank you very much.
I'd like to say good evening to the committee. I appreciate y'all giving me the opportunity to speak in front of you. My name's Derek Liggins. I'm here in support of Senate Bill 1030. The laws around expungement are one of the main causes for the lack of growth in the Black community. With a favorable vote on this bill, it will change lives, remove some of the barriers that impact returning citizens so they can be successful if we truly believe in rehabilitation. I'm a returning citizen living in Baltimore City's 45th district. My conviction in question is from 1994. From 1994. Since then, I've become a homeowner. I've been employed with the same mechanical engineering company for the past 15 years. I'm a different person today than I was 30 years ago. My record has directly affected my income. As my company takes on more government contracts, I cannot work these government contracts because of the current expungement laws. With the scale wages paid on these government contracts, I could earn an extra $20,000 to $30,000 a year on my salary. This bill can make a difference in my life, my family, and many people like myself. I just ask for a favorable vote on this bill. Thank you for your time.
Hello, good evening. My name is Judge Karen Friedman. I was a judge in Baltimore City for over 20 years until I took another position a couple of years ago. I'm here today in my personal capacity as an individual who sat as the expungement judge for Baltimore City for many years. I'm taking personal leave from my current position because this issue is so important to me, and I want to strongly support this bill. To many people, this is a theoretical conversation, a conversation devoid of any connection to the actual implications of receiving or not receiving an expungement. But when you are a judge and have the individual who this is affecting in a have the individual who this is affecting in a very practical way, standing 5 feet away from you, the theoretical becomes very real. You see the look in the person's eyes. You hear the desperation in his or her voice. You witness the confusion that sets in when they realize that although they truly believed our society that told them if they did right, cleaned up their act, started living like the rest of us, we, society, will forgive and allow them to achieve. Yet here they are, weighed down with an albatross, sometimes from years and years ago, that the law won't allow them to shake. They can't get a bank loan or serve on a jury or get a business license. And more importantly, they can't regain their name or their dignity. Allowing a judge to truly look at the individual in front of them and analyze where they are in terms of their growth, how far they've come from where they had started, how much they need that expungement is so necessary. It is critical. A judge can look at a person in a holistic manner and truly assess, not in theory, but in reality, the collective accomplishments of that individual and whether or not he has earned true forgiveness. Give your judges the discretion to make these case-by-case decisions. We are in a country that says that we believe in second chances, but are we really? We need to allow people to reintegrate, not just re-enter. The expungement is one of the most important tools to make that happen. I strongly support this bill. Thank you.
Thank you, Mr. Chair. Judge Friedman, could I ask you a couple of questions?
Of course.
You need to go back to the podium. We don't get you on camera unless you're at the podium. Sorry.
I don't really tend to be here or do this, so.
No. Every single witness standing here has to be asked to do that the first time they're here. From now on, you'll know.
There you go.
Okay, so in the current expungement law, we have lots of time periods. It's generally 5 years after things have accomplished, some 10 years, 15 years, et cetera. But this bill says a court may grant a petition at any time. So does this bill override the 5 years, 15 years, 7 years that's currently in the law?
So that is my understanding, right? But I really think that two things. First of all, I think the bill is really focused. I think the statistic is that 93% of crimes on the book today are not expungible. So this is really about focusing on that large percentage of crimes that are not expungible, like what happened to this gentleman, right? And to allow a judge to look at the overall circumstances and the entire picture and say, you know what, maybe this crime is not expungible, but look what this man has accomplished, right? He is a prime example of the things that we would look at. He's not just re-entered, he's reintegrated. He has a success in business. He owns his own home. No. He's a father. So these are the type of things we're going to be focused on. Yes, we can technically, based on this rule, my understanding is that we could override some of the time periods, but we also have to really look at the good cause. So when someone comes within 5 years and said, I want an expungement, when they have, they're going to be expungible in 2 years from now, they're going to need to show a judge why they need that today, as opposed to waiting the 2 years.
Well, let me ask you this.
Mhm.
Well, a lot of what you say I'm sympathetic to, but we've spent a lot of time during my years in the General Assembly figuring out what those expungement periods should be and enacting them into law. Would you have a problem if we amended the bill to leave in the current 5 years, 7 years, 15 years for those specific offenses, and only had this bill apply to other offenses which are not encompassed in the existing statute?
So I like the bill the way it's written. I would not say I would have an objection, because I've learned already that I will take victories where I can find them. So, listen, you entrust judges with making such huge decisions, right? We're sending people into prison for life. We're making life and death decisions all the time, right? This is something that you should be able to trust us with, right? We make much weightier decisions than this all the time, every single day. So trust us to be able to look at an individual and see what they've really accomplished, understand their personal situation. Like Senator Carter said, we don't want a cookie cutter solution. Everything doesn't work for everybody. A judge can look at that and see the entire picture.
All right, well, let me ask another question if I could. I've got two more. So
Sure.
Here's the first of the two. Why expungement? Why not shielding? If someone has been convicted of rape and sentenced to jail for rape and gets out of jail for having raped someone, should that person immediately be able to come to court and get an expungement for good cause, so that if he rapes someone 6 months down the road, the judge that will sit on that case to sentence him on the successive rape would not be aware that there has been a prior rape conviction by this person? Shouldn't judges at least be able to know what the prior convictions were?
But in your example, sir,
Yeah.
I don't even think shielding would have been appropriate, right? Meaning, if someone's, just got out of prison for rape, I can't imagine any judge looking at that individual case and he just got out and be able to find good cause.
Well, that's going to be my third question.
For shielding or for expungement, right?
That's going to be my third question.
Right.
So let's deal with it.
Right, but
why should judges not be able to know what the prior convictions of any individual have been at the time that the person has been convicted of another crime and you're there to sentence the person?
Okay. But the premise is that part of good cause is the judge weighing the possibility of recidivism, right? So,
but if we have expungement, the judge will not be aware of a prior conviction.
But again, the expungement would only be given once a judge had made that decision that this person is not a risk for recidivism. A judge is not going to find good cause if they are scared that that person might recidivate.
Well, let's come to the third question. This bill contains no definition of good cause at all. Isn't it likely that you would have your own definition of good cause, and a judge in Frederick County would have a different definition, and a judge in Prince George's County would have yet another definition, because there's no definition provided in this bill?
Well, first of all, there are criteria. Okay, so there are
In the
things
bill?
that the judges have to look at. Yes.
Okay.
And let me just say, I could not even, that is such a great conversation. I cannot begin to tell you how it's like that for everything. Okay. It's like you have, there are places in Baltimore where one corner is Baltimore County and one corner is Baltimore City. And if you get caught on that corner instead of that corner dealing, what's going to happen to you? It's so different. And if you're found in Frederick County, so different. All our laws, unfortunately, are applied so differently depending on your geographic location. And frankly, the judge that you're in front of. Every judge comes to every case with their own glasses and their own view of the world. So that actually is true for everything. But the bill does have in it things that have to be looked at in order to define good cause.
Well, let's come back to my question of rape then. So I'm looking now at the criteria. The judge has to consider the nature of the crime.
Mhm.
But we're talking now about a person who served his time in jail.
Mhm.
But let's assume, let's take a hypothetical. The person in jail was not a disciplinary problem. He followed the rules. He was like a model prisoner. So the person now gets out of jail. And so he's asking for an expungement for a good cause as soon as he gets out of jail. You're going to look at the nature of the crime, the person's character and history, the person's risk to public safety, person's success at rehabilitation. Isn't it possible that you're going to make a decision in Baltimore City one way, and the judge up in Carroll County is going to make a decision another way, and the judge in Prince George's County will make a third decision, all with the same information.
I mean, if you
And
look,
then once one of the judges has decided, okay, I found good cause, that means that no other judge in that jurisdiction, or I guess anywhere in the state, if he were to commit another rape, would be able to know that he previously was convicted of rape when sentencing the person for a second rape.
based on the criteria, and number one is the nature of the crime. If you're talking about a crime like rape, right?
Right.
I can't see any judge in any jurisdiction
Ever expunging the.
Well, maybe 20 years down the road or something where he's already been a model, citizen and has employment and is been doing everything right. I never want to say never, right? Because there have been cases where people have had a murder conviction expunged, and they're heading some of the largest nonprofit organizations that I've seen. And I'll tell you a quick personal story. There isn't a very large nonprofit organization, I won't mention the name, where that I work with at my current position at the Department of Justice. And that individual who runs it was convicted when he was 17 of murder. It was a gang situation where one gang member killed another gang member. He served about 25 years. He came out and literally has turned his life around. Like I said, he heads one of the largest nonprofits in the state of California. And I was traveling with him to go look at different prisons in California to see how we can improve the conditions. And we were trying to figure out where we were going to stay. And we were going up to Pelican Bay, which is very isolated. There's no hotels there. And we were saying, maybe we should stay at an Airbnb. We'll get a 2-bedroom Airbnb. And my husband says to me, "You're sharing an Airbnb with someone who was convicted of murder?" Like, he looked, and I know Sam, this guy, so well. It didn't even occur to me because I know him as a person. And I said to him, honestly, sweetie, I would let him babysit our grandchildren. I know this man and I've seen what he's done with his life. And he recently got that murder conviction expunged. And if I could tell you the incredible things that this man has accomplished since he got out, it is absolutely mind-blowing.
Yeah, but if he were to then commit another murder.
But he never.
And he wouldn't be the judge.
But
He'll be a different judge.
The point is, if we truly believe in rehabilitation, right? That's not a possibility. I would bet my house on it. I would bet anything on it that individual will never do anything like that. Because again, he truly has been rehabilitated. We have to believe in people's ability to change. And when they're 17 and when they're 57, they are not the same person. And to keep them down from what they could possibly achieve because at 17, they did something really stupid. Again, rape is we take the most horrific example, right? Almost more horrific than murder in some ways. Okay. That is a different type of crime, and we treat it differently because we have all these, monitoring laws because for a lot of, the science really shows that rape or sexual offenses, there's more of a psychological piece of it that goes along with it. So there are very other complicated issues with it.
I hate to interrupt, but
Sure.
it's getting late.
It is.
And you obviously are very enthusiastic about this issue.
Passionate.
You have me with you on the shielding part of it. You don't have me with you on the expunging part. because I'm just concerned that if I were a judge and someone came before me, I would sure want to know that that person had been convicted of the same crime 20 years earlier. And at the time that I'm sentencing him a second time for having committed the same offense. But thank you for your testimony.
I understand. I understand.
All right, thank you very much.
May I promise to be very
Sure.
brief, but the senator asked the judge the question, but since this is my second year with the bill, as I've talked about before, I would not have a problem if the only way we could get this done this year, because we do believe in baby steps and rather than actual like transformational change, with keeping in the guardrails that are in place and doing what you suggested regarding other offenses that are not currently expungible under statute. But what I would suggest to you on the other point that you made is that under our current law, where we have these arbitrary guardrails, these arbitrary amounts of times, these arbitrary crimes, it's all arbitrary. None of it's science evidence-based, none of it's scientific, none of it's based on good cause. It's all arbitrary. In those instances, once a person finishes, the time passes and they get the expungement, if another, and they do the same thing in 6 months, they come back, the judge doesn't know because it's expunged under the current law with the arbitrary time frame. So I don't think that your point has validity necessarily with respect to this law, because it would apply to all of the other expungement laws. Thank you.
All right, thank you, Senator Carter. With that, that'll conclude the hearing for Senate Bill 1030. We'll now move on to Vice Chair Waldstreicher with Senate Bill 948. I didn't. Mr. Hill, you're right. You're absolutely right. Come on up. Thank you for, no worries.
But if I could, Robert Hill, on behalf of the Montgomery County State's Attorney's Office and the Maryland State's Attorneys Association, we respectfully oppose this bill. I would tell you that it's not lost on prosecutors, the balance between public safety and rehabilitation and community reentry. We understand that, and I understand the efforts that Senator is making on behalf of those who are and want to do well after they've served their sentences. The concern that I have is that Senator West, I believe you said something about shielding versus expungement, and I think we'd be much more open to that, because I'm very concerned. You have somebody who commits a first-degree burglary or steals $100,000, and they do their sentence. Let's say they're put on a couple of years probation. They get off the probation, and they immediately go and apply for this expungement. One of the, I guess the things that judges are looking at are, well, the nature of the crime, number one, but also they're charged with looking at the person's character and history. Well, if the history is very abbreviated, I mean, what we're seeing is how they did on probation. But what about 2 or 3 years after they left the supervision of the court? How did they do then? We believe that the courts should be able to look at a track record, and there's no track record that would have been developed for somebody in that position, and that would go into the calculus of their risk to public safety. We know maybe they committed this first-degree burglary, but we don't know how they do after they're out. The other issue, I guess, is their success at rehabilitation. That's another thing that would lack a track record. With respect to the good cause provision, which is not defined, it seems to me that the mantra would probably be, I can't find a job. And, you know, that's a part of it. If you commit a felony theft, for example, or a robbery or a burglary, people are going to question. There are people who will hire people who do that, and that's a good thing. But from the state's perspective, from public safety standpoint, and I'm going to finish, we believe that people should be able to make an educated decision on that. So the bottom line is, I hear you, Senator, on the issue of shielding. We would be more amenable to that, but we otherwise would oppose an expungement.
Excellent. Thank you very much, Mr. Hill.
Thank you.
Seeing no questions from the committee, that will most assuredly end the hearing for Senate Bill 1030. All right. Thank you very much, Mr. Hill.
Thank you.
All right. We'll now move on to Vice Chair Waldstreicher with Senate Bill 948.
Thank you, Mr. Chairman, members of the committee. We've had a bill on this issue for the past few years. And the bill in front of you is related to prison phone calls. It's an interesting issue. When you are incarcerated, you don't pay for your soap in the shower. You don't pay for the food that you eat. You don't pay for the cleaning that goes on. But for reasons that are unclear and historical and unjust in any case, people have to pay for their own phone calls outside of the prison. They have to pay for phone calls to their parents. They have to pay for phone calls to their loved ones. They have to pay for phone calls to their children. It's not acceptable. And in this committee, we've started the process of looking at all these costs that we foist upon defendants and incarcerated individuals who don't have the ability to pay. That includes GPS monitoring costs, the supervision of probation costs that we've talked about, and then this critical one, prison phone calls. All the studies show that when you allow people to make calls freely from prison, those calls are made to connect with the people that are dear to them and keep them connected to the community from which they came. And upon release from prison, the connections that they've made from prison become an important part of their reentry. And those prisoners who have had free and easy access to their loved ones are able to reenter back home in a much smoother, more careful, more loving way. And that gets folks back into the mainstream economy much faster. And most importantly, it prevents recidivism in our community. And that's what we're trying to prevent. I've worked with a number of incredible advocacy organizations that you're about to hear from on the legislation that is in front of us. But ultimately, I think this is an easy lift. People shouldn't have to pay for a portion of their own incarceration. That's a responsibility of the state. That's a responsibility that we should all take on. And I ask for a favorable report. Please.
All right, yeah. Thank you so much, Senator Waldstreicher, and good afternoon, members of the committee. My name is Alyssa Akbar, and I'm a policy associate at Worth Rises, a national nonprofit dedicated to ending the exploitation of people impacted by incarceration. We've helped jurisdictions across the country pass and implement policies that make communication free for incarcerated people and their support networks, including in Connecticut, California, Minnesota, Massachusetts, and Colorado. With this bill, Maryland has the opportunity to join these other states in providing overdue relief to millions of families with incarcerated loved ones by simply making communication free. Maryland's families currently pay the state's prison telecom vendor, Global Tellink, an estimated $12.3 million each year to simply speak to their incarcerated loved ones. Families are often forced to choose between paying for basic necessities, housing, and food, and paying to hear the voices of their incarcerated loved ones. In fact, 1 in 3 families with an incarcerated loved one goes into debt just to try to stay connected, and 87% of those carrying this enormous financial burden are women. Like the senator was saying, family support can change how successful a person is both during and after their incarceration. It increases hope, reduces desperation, and encourages positive behavior, which in turn reduces violence and improves the correctional environment for incarcerated people and correctional officers alike. Further, incarcerated people who maintain connection with their family and community during their incarceration have a better chance at successfully re-entering the community upon release. With their family's help, they're more likely to secure housing and employment and generally just have a better transition. This increased success translates into lower recidivism and increased public safety. Based on our work across the country, we estimate that providing free phone calls to incarcerated people and their loved ones will save Maryland families $12.3 million annually and cost the state $3 million per year. This fiscal assessment assumes that Maryland is able to secure similar rates to other states that have prioritized low costs, or specifically 1 cent per minute, as charged roughly in Illinois and New Hampshire. At current phone call volumes, which are not expected to change given current usage, providing free phone calls to Maryland families would cost the state $3 million per year. We respectfully request a favorable report on this bill. Thank you.
Thank you so much.
Can you hear me? Thank you, Senator Wallstreicher and esteemed members of this committee. My name is Michelle Kennedy Quadio. I reside in Montgomery County. I'm a voter, I'm a homeowner, and I call my senators and I call my delegates for help on this, but I'm the mother of an incarcerated son at a Maryland correctional facility. I'm here to urge you to support Senate Bill 0948. About a month ago, I got a call. Mom, I'm in a lot of pain. I've been asked to be seen by a doctor for the last few weeks and I haven't been seen. I think they've marked my file and they know who I am. I've talked to the warden at the institution. And that day, by some miracle, because my son was able to call me, he was seen. They assessed that he had an abscess that had been long-standing, and that Monday he was seen. Recently, a woman shared with me just a few days ago that had her son not told some fellow prisoners that he was going through a medical emergency. And if one of those people had not called her, she would not be aware that her son was in a critical emergency. These free telephone calls are a lifeline for people in prison. We have 15,500 people in prison like my son. Since COVID, and due to what they call cost containment measures because we're severely understaffed in our Maryland prisons, these telephone calls have become an increasing lifeline. And if we look at this as a rehabilitative measure to avoid recidivism and, bring a healthy person out of the prison system, these calls make a difference.
If you want to briefly conclude.
I'll briefly conclude by saying I spend $400 a month, including the telephone bills, because my son makes $20 a month for a 30 or 40-hour work week and cannot afford this. There are many in prison that don't have this option. And so I would urge you all to support this bill. I think it's important. It'll affect me positively and many other families in Maryland.
Thank you for your testimony. Any questions for the advocates or for me? Senator West.
Actually, I've got a question for the sponsor. So last year, a similar bill came before us. I think you were the sponsor last year, but last year's bill was a task force. This year's bill is not a task force. What's happened in the meantime?
Thank you, Senator West, and I'll just answer from here if that's okay. I apologize under the circumstances. I support the pure bill, which is the bill in front of you. As Senator Carter kind of recognized in the previous bill, which is unrelated to this, but we can do big things. And this is a really important step in the right direction. And philosophically, I think we're all aligned that folks shouldn't be paying for the cost of their incarceration. They shouldn't have to pay $400 to stay in touch with their loved ones. I recognize that the bill has a fiscal note. I know the advocates believe that the fiscal note may be overstated, but nonetheless, the fiscal note is substantial. So I think there'll be a question for the advocates at some later point as this bill moves forward about if there's not support to move the pure bill forward because of the costs, whether we try to keep the momentum going through a task force or some other way, including possibly just delaying the effective date of the bill to allow the department enough time to adjust to the costs.
Great. I've got one further question.
Yeah.
As long as we're talking. There is, as you mentioned, a fiscal note, and the fiscal note is pretty high, but the advocates seem to think it really when they cost it out, it's going to be less money, but we're talking about millions of dollars. So my understanding is, maybe I'm wrong, that prisoners in jail earn money for the work that they do in jail, whether it's running the prison library or working in the food preparation or whatever. Isn't it possible that the prisoners could use a portion of the money they earn in jail to pay for these telephone calls?
So I'm gonna defer because I think there was some testimony about the differential between what was earned. Why don't you come up to the podium about the amount that's earned per month versus the amount of cost per month? And I think that'll show you why that might not be viable.
Okay, great, thanks.
Thank you for the question. Yeah, my son, as I said in testimony, he works a 30 to 40-hour work week, whether it's in food prep or sewing garments, and he makes $20 a month. And that is
$20 a month?
$20 a month. That is the norm. So
wow.
I would re-educate on that point. Yeah, it's $20
why that's
a
not
month.
enough to pay for the calls.
Right. Thank you, Senator West. My phone cost is actually hovering around 30, a little bit more now, because we're not able to visit because of these cost containment measures. So rely more heavily on these urgent phone calls, or just phone calls to stay in touch. And also, most of the people are behind bars 23 hours out of a 24-hour day, not just because of an infraction or something going on in the prison, but because they don't have enough prisoner guards. So, these calls are really more of a lifeline than they used to be.
Thank you very much.
Thank you, Senator.
Thank you, Senator West. Thank you all for your testimony today. That concludes the hearing on Senate Bill 948. We really appreciate your being here. Now we'll go on to Senator Reedy for the final bill of the day, Senate Bill 1075. If you'd like to bring your panel up.
Thank you,
Senator.
Mr. Chair. I believe we have our state's attorney, Haven Shoemaker from Carroll County. Who else did I have down? I had Scott Broadfoot down, I believe, as well.
And we've got a council member from Montgomery
And
County. if
yes,
you'd like to bring her up.
Councilwoman Lutke as well.
I think council member Fanny Gonzalez is here
Oh, I'm
today. If
sorry,
that's
okay.
okay.
Just come right up. Yes, I had the wrong name. I apologize. Please come up. And we have some other folks to testify as well after me. And Mr. Chairman, before I begin, I want to stay as long as I can, but apparently I've been double booked. So I may have to slip out to go give testimony in another bill in another committee. And I'll try to bounce back and forth and keep track. Thank you so much. So Mr. Vice Chair, members of the Judicial Proceedings Committee, Senator Justin Reedy here to present Senate Bill 1075, criminal law, distribution of heroin or fentanyl causing serious bodily injury or death. We call it Victoria and Scotty's Law. This bill would create a new crime for the distribution of heroin or fentanyl, which results in death or serious bodily injury of another. It would carry a maximum sentence of 20 years in prison. In the bill, distribute does not include the sharing of heroin or fentanyl without remuneration or the exchange of goods or services. This bill is strictly targeting drug dealers who sell this poison in our communities. Under current law, in most cases, outside of charging a drug dealer with distributing a controlled dangerous substance, it is almost impossible for a state's attorney to hold a drug dealer accountable for selling this lethal, poisonous product that everyone now knows full well is extremely likely to kill you. Additionally, this bill provides a Good Samaritan provision. So a person it preserves the good faith Samaritan provision. If you assist someone with medical assistance, experience a medical emergency after a fentanyl use, you're immune from criminal prosecution. So we continue to maintain that preservation. The goal here is to go after the people who are selling these drugs in our communities, knowing full well the fatal likelihood that can result from it. This is bipartisan, common sense legislation. It's much needed to allow prosecutors to hold those accountable who knowingly sell this poison. It's resulting in the death of almost 200 people on average every day in the United States. My testimony had an incorrect stat. 24 states have already passed similar legislation that holds drug dealers accountable when they sell a lethal product that kills someone. That includes states like as diverse as Washington State, New Jersey, and Colorado. I respectfully request a favorable report on Senate Bill 1075, and you're going to hear today from a great panel here, but also a number of parents and family members that have lost loved ones. And we want to honor that and be able to get justice for people who experience this loss. Obviously, we want to continue working to reduce drug addiction, but we also need to hold people accountable that are pushing this. So with that, Mr. Chair, I'll step aside and go to our next person on the panel. And I'm agnostic as to who goes next. We want to have a councilwoman from Montgomery County.
Sure. Ladies first.
Yeah, exactly.
Good afternoon. Hi. My name is Natalie Fanny Gonzalez. I'm a council member in Montgomery County. And let me tell you why I'm here today. Not just by myself, but I came here with people, with moms, and business owners for my district who are going to share their story. I'm here in support of Senate Bill 1075. Let me share a story. When I joined the county council about a year ago, one of the very first phone calls that I received as a council member was from a mom whose kid died in January 2023, and she's here with us, and she'll be testifying, and I'll translate for her, by the way. Her kid died due to an overdose of fentanyl. So when I heard that story and I got really focused on really looking into this issue, I come from the Park and Planning Commission. I'm a land use nerd. This is so new to me. I found out that we have no place in Montgomery County or in the state to place kids who were addicted to fentanyl, for example. So number one task that I have was working with the county executive's office and with the governor of Maryland to ensure that Montgomery County will have the funds needed to ensure kids who are using fentanyl had a treatment center. Nowadays in Montgomery County, we have 4 treatment centers. So if kids who are dealing with drugs have this issue, and it's all paid for free, okay? So that's great, but that's not the only solution. We have a legal system, a criminal system that needs to be updated, and that's how this bill comes in. I'm not gonna describe the bill because it was already explained very well, and we don't need to repeat myself. So with that, I'm just here to please do something because this drug is poison. And it's killing our communities. Is that it doesn't discriminate based on gender or income or if you were born here or not. It's killing everybody, and it's scary, and it's happening in our own backyards, and we need to do something. Thank you so much for your time. Yes, I'm taking charge now.
Hello, everyone. Good evening. First, I'd like to take a moment to thank everyone's efforts, especially those directly connected to my family today. Today, I'm speaking in favor of Victoria and Scotty's law. On April 12th, 2019, what my wife and I knew as life was shattered and was no longer. Our son, Scotty Broadfoot Jr., was found dead, alone, in a bathroom from fentanyl poisoning. Scotty purchased what he thought was $20 of cocaine. Instead, it had 2 types of illicit fentanyl. Scotty was known for his kind heart and his goofy personality. Everyone loved Scotty, and he brought a smile to your hardest times. After Scotty's death, I investigated the past for an answer. It all started in high school. Scotty was undersized for his age, and he had a speech impediment, which resulted in being bullied and assaulted. This extremely dramatic situation played a role in Scotty's everyday thoughts and actions. Unfortunately, Scotty started drinking alcohol to help him get through life, feeling better about himself. As a result of drinking and partying, Scotty broke his arm. This resulted in not being able to work. Now, Scotty didn't have the funds to purchase alcohol. Scotty felt he needed something to feel normal. On April 12th, 2019, Scotty purchased cocaine, also known as fire. Scotty was dead. I will never see Scotty smile again, even though his dealer had several arrests with fentanyl involved. He still smiles every day and is free on the streets. I don't know how many lives this dealer has affected, but I do know
With Victoria and Scotty's law in place, this dealer would be in jail and not be able to harm anyone else's loved ones. Please vote yes, not only for my family, but for every Marylander. Scotty was deeply loved, will be forever missed, and will never be forgotten. There is now a void in our hearts that will never be filled. And what's most important, this is not a red or blue issue. This is a red, white, and blue issue. Thank you for your time.
Mr. Vice Chair, members of the committee, I know you put in a late day. I don't miss those, by the way, being down here, but the reason that I'm here is because every time dealers sell heroin or fentanyl, essentially what they're doing is they're playing Russian roulette with the lives of the people that they're selling to. In my county, almost 100% of the overdose fatalities over the last 3 years have been from fentanyl. And nowadays, fentanyl is being pressed into pills. It's being sold in powdered form. It's being mixed into every illicit drug you can imagine. It's even being put into vape juice. And what's remarkable about that is that 0.00007 ounces is enough to kill you. That's 2 milligrams, and the average housefly only weighs 12 milligrams, just to put that in context. In 2023, 112,000 people died from overdoses in the United States of America. So I think it's time that we went after the supply. And when I mean supply, that means going after the dealers. Now, the bottom line is that as prosecutors, we could possibly pursue charges under a Maryland Court of Appeals case, now the Supreme Court, in the State versus Thomas, that allows you to go after somebody that's a drug distributor if you can show gross negligence. It'll be gross negligence, involuntary manslaughter, but the standards set forth in that particular decision are kind of hard to prove beyond a reasonable doubt into a moral certainty. And that's why we're here today to ask for a legislative fix. This would give us another tool to go after dealers in a very serious way. I would ask the committee to give a favorable report, not just for Scotty and Victoria, but the thousands like them across the state of America and frankly across the whole United States who have lost their lives from drug overdoses. So thank you, Mr. Chairman.
Good afternoon, Mr. Chairman. Robert Hill on behalf of the Montgomery County State's Attorney's Office, as well as the Maryland State's Attorneys Association. I want to thank Senator Reedy for sponsoring this really important bill. The heroin fentanyl crisis has been with us for some time now, and the 5 alarm bells are off right now. It is just simply, it's crazy. I remember being here 7 or 8 years ago, and we were trying to pass legislation that dealt with distribution of opioids. It was more generic than this bill, and it was right sort of before everything broke loose. And we've seen how many people have died with this terrible drug, fentanyl, and of course heroin. I will tell you from a prosecutor's perspective, I understand that just the deterrence aspect, what we're talking about today, is not the only thing, but it's what we're talking about today. I understand that we have to deal with the demand on the other side and the services that can be provided to people to lower that demand. But my office has had to use either involuntary manslaughter or depraved heart murder. We recently, my office prosecuted an oral surgeon who had given his girlfriend over a period of time drugs, and he was successfully prosecuted. But that was a very unique situation. That's not a tool that would be ordinarily available to us. This bill gets right to the point. It tells us that distribution of CDS is not a victimless crime. It says if you distribute fentanyl or heroin or a combination of substances that include it, and it results in somebody's death, that you are going to be held accountable for it. And what it does, just very briefly, it adds a 20-year penalty. I'll be very quick. 20-year penalty on top of the 20 years that a person would be subject to. It's not to say they would get the full 20 years. It's not a mandatory minimum, but they would be exposed if they were convicted of both distribution and distribution resulting in death to a possible consecutive penalty totaling 40 years. Sharing is not distribution. There's a good Samaritan provision. If you call the police and you say, my gosh, my friend here is dying, you're not going to be prosecuted for that.
Mr. Hill, I'm going to have to ask you to conclude, please.
Yes, that's all I have. Thank you.
Thank you so much for your testimony here today. Any questions for the sponsor or this panel? All right, seeing no questions, we'll move on to the next panel. Senator Reedy, I don't know if there's any particular order. I can just sounds good. Okay. Anita Puckett, Edith Montalvan, Roberta Vieira, Isis Flores, Amanda Bass. Understood. Completely understood. Whomever would like to go first.
Hi, thank you to the committee. My name's Anita Puckett. I'm from Cecil County, Maryland. My son died from illicit fentanyl poisoning 27 July 2021 at 27. He was a very kind, bright, handsome young man whose life was cut short because a drug dealer sold him something other than what he intended to take. This is the very definition of poisoning. Kevin suffered from substance abuse disorder. He began using heroin at the age of 18, went to rehab several times, had lots of sober time. In fact, his last time in rehab was to get off of methadone. And then he went directly into a sober living home from there. So Kevin had not tried to purchase heroin for 2 years before he passed in 2021. Kevin relapsed, and within 3 weeks, he was dead. Kevin did not realize in the 2 years he had not used heroin that heroin supply had been completely inundated in the United States, and everything basically was fentanyl. There was no heroin in Kevin's system. It was 100% fentanyl. My son is gone, but this dealer is likely still peddling their poison and actively murdering people. These dealers continue to murder with impunity because there's no deterrent to their actions. They're literally getting away with murder. There must be stronger laws put in place to prosecute dealers that kill with this poison. And I often wonder how many more people did this same dealer murder after he murdered my son. There are no more memories we can make with Kevin that was stolen from us by a drug dealer that has no regard for human life. My family, along with thousands of other Maryland families, need this bill to pass to save lives and receive justice for the senseless poisoning of our children by criminal drug dealers. We're losing a whole generation. Right now, Maryland politicians have opportunity to support a bill that can help prevent increasing deaths from this poison in our state. Maryland families need your support instead of the ongoing failure to hold these criminals responsible. Thank you.
Thank you.
Good evening, everyone. My name is Roberta Vieira, and I'm the owner of a small family business in Wheaton, Montgomery County. And over the recent years, my business has been robbed so many times. Shoplifting has been increasing in the area, and that means products are being taken off my shelves, which impacts the revenue that help me sustain my family and the families of those who work with us. It's disheartening and distressing work in an environment that's prone to theft It's causing me emotional distress and financial hardship. I've been working at my store for nearly 23 years and Maryland resident for longer than that. I choose Maryland to raise my family and to start my business. And it's been difficult watching the decline of our city due to influence of drugs. I have never witnessed our city in this state before, and it's discouraging watch a community decline due to impact of fentanyl over the past few years. I'm in favor of Maryland State Bill SB 1075, which is expected to strengthen criminal prosecution against the sale and distribution of deadly drugs in Maryland. I believe this bill will help protect business owners in Maryland, as well as help Wheaton residents avoid contact with fentanyl. I believe this bill will make our city better, and as we come to work every day, it will help me feel safer again, while ensuring the safety of my employees and family and contributing to the local economy. Thank you for taking this legislation into consideration. Thank you.
Buenas tardes. Estoy a favor de la ley SB 1075. Mi nombre es Isis Flores y quiero hablarles sobre la pérdida devastadora que hemos sufrido en nuestra familia. Yader Rosa Flores, mi hijo de 16 años, falleció a causa de una sobredosis de fentanilo el 10 de noviembre del 2022. Su partida dejó un vacío inmenso en nuestras vidas y nos llevó a descubrir la realidad de esta droga tan destructiva.
My name is Isis Flores, and I'm here in support of SB 1075. I want to talk to you about the devastating loss that we have suffered in our family. Yader Rosa Flores, my 16-year-old son, passed away due to fentanyl overdose on November 10th, 2022. His departure left a huge void in our lives and led us to discover the reality of this destructive drug.
Hoy estoy aquí para ser la voz de tantas víctimas como Yader, quienes han perdido la vida a manos de narcotraficantes que distribuyen esta droga mortal en nuestras comunidades. Es necesario que se haga justicia por todos los jóvenes que han sido víctimas de esa tragedia.
Today, I'm here to be the voice of so many victims like Yader who have lost their lives at the hands of drug dealers who distribute this deadly drug in our communities. It is necessary that justice be served for all the young people who have been victims of this tragedy.
Por eso hago un llamado a los responsables de legislar en nuestro estado para que tomen medidas más estrictas contra aquellos que trafican y distribuyen fentanilo y heroína. Pedimos que se apliquen penas severas a estos criminales y que se brinde todo el apoyo necesario a las autoridades para detenerlos.
This is why I call on those responsible for legislating in our state to take strong measures against those who traffic and distribute fentanyl and heroin. We ask that severe penalties be applied to these criminals and that all necessary support provided to the authorities to stop them. Hay que di la última parte que ya no. Okay. Oh, thank you.
Es fundamental que se escuche la voz de las víctimas y se actúe con determinación para acabar con este flagelo que está acabando con la vida de nuestros jóvenes. Como madre que ha sufrido esta tragedia, insto a que se cambie la ley y se persiga de manera incansable los responsables de llevar este veneno a nuestras calles.
It is essential that the voices of victims be heard and that decisive action be taken to end this tragedy, taking lives of our youth. As a mother who has suffered this tragedy, I urge the law be changed and that those responsible for bringing this poison to our streets be pursued.
En nombre de Yader, mi hijo, un joven inocente que perdió la vida por esta cruel realidad, les pido su apoyo y acción. Confío en que juntos podremos hacer la diferencia y evitar que más familias sufran esta dolorosa pérdida. Gracias.
On behalf of my son Yader, an innocent young man who lost his life to this cruel reality, as I ask for your support and action. I trust that together we can make a difference and prevent more families from experiencing this painful loss. Thank you so much for your time.
Estoy a favor de la ley buenas tardes. Estoy a favor de la ley SB 1075. Mi nombre es Edith Montalbán y soy la madre de Ashley Edwards, una estudiante de 15 años de la escuela John F. Kennedy, quien lamentablemente falleció el 14 de enero del 2023 a causa de una sobredosis de fentanilo, esta droga que está causando estragos en nuestras comunidades. Y es importante que tomemos medidas para combatir esta crisis que está cobrando la vida de tantos jóvenes.
My name is Edith Montalban, and I'm here in support of SB 1075. I am the mother of Ashley Edwards, a 16-year-old student at John F. Kennedy High School in Glamont, who tragically passed away on January 14, 2023, due to a fentanyl overdose. This drug is destroying our community, and it is important that we take action to combat this crisis that is claiming the lives of so many young people.
No hay dolor más grande para una madre que perder a su hijo, y mucho menos de esta manera tan trágica. La adicción es una enfermedad y nuestra comunidad inmigrante carece de los recursos y apoyo necesario para ayudar a aquellos que se ven afectados por esta enfermedad.
There's no greater pain for a mother than losing her child, much less in such a tragic way. Addiction is a disease, and our immigrant community lacks of the necessary resources to support those who need our help.
Sin embargo, ustedes sí pueden ayudarnos endureciendo las leyes para frenar la venta, distribución de esta droga letal. Nadie va a devolverme a mi hija. Yo no pido castigo para los jóvenes consumidores. Mi punto aquí es que hagan lo que puedan para frenar la distribución y evitar otras víctimas inocentes como Ash y otras madres desconsoladas como yo.
However, you can help us by straightening the laws to curb the sale and distribution of this lethal drug. No one will bring my daughter back to me. I'm not asking for punishment to consumers. My point here is that you do what you can to stop the distribution and prevent another innocent victim like Ashley and another grieving mother like me.
Agradezco su atención y apoyo en nuestra lucha contra la droga letal. Muchas gracias.
I thank you for your time and your support for fighting illegal drugs like the fentanyl. Thank you for your time.
Sure.
Good evening. My name is Sheila Snell, and I'm a resident of the Longmead Crossing community in Silver Spring, Maryland. I'm in favor of SB 1075. I'm present today as our neighborhood is suffering due to crime, drug abuse, and violence. I've seen firsthand the shocking effects of heroin and fentanyl in my community that basically was taken over as a direct result of these drugs. These drugs resulted in the theft of any and everything in our community. It totally changed our lives. Bill 1075, SB 1075, is a critical step in combating this epidemic and holding those responsible for the sale and distribution of these dangerous drugs accountable. I fully support this bill and urge lawmakers to pass it in order to help make our communities safer and protect our families. I've lived in my community for over 30 years. This weekend, I went to a well-known fast food establishment in my community. This place is well known for the purchase of fentanyl. Because I was aware of this, I hesitated if I would be safe to even go through the drive-through. I've never had to think twice if I were going to stop anywhere in my community because I felt it was unsafe. This should not be. It's imperative that this bill is passed. It will definitely help make a difference in our communities. Thank you.
Chair and committee members, thank you for letting me speak. My name is April Babcock. I lost my son, Austin Connor Babcock. This past January was 5 years since his passing. I've started a nonprofit organization, Lost Voice of Fentanyl. I live and breathe fentanyl. It never sleeps. About my son's story. So when my son passed away, 3 months after my son's death, the dealer that sold him fentanyl, which my son didn't even know he was buying fentanyl, so he was flat out deceived. He didn't have an opportunity to say, hey, I don't want that cocaine. It's got fentanyl in it. He was robbed of that opportunity. But 3 months after my son's passing, the dealer that sold it to him, I have the police report with me. I have everything. He was caught with a bunch of drugs, but here's the kicker. The one drug he was caught with, 5.58 grams of fentanyl and cocaine, the same drug that he knew just killed my son. So he had zero remorse for loss of life. He was locked up, got right back out. Why, I have no idea, but he was let right back out of jail. And 6 months after he was let out of jail, he was murdered in Baltimore City, September 19th of 2019. If he were in jail where he belonged, he would not have been murdered. So I'm here testifying in favor of this bill, but also to keep Marylanders safe. You're giving an opportunity to every drug dealer to change their behavior. Without accountability, these drug dealers, money trumps human lives. There's a lot of money in dealing drugs, and that's just the truth. They have no reason to change. So we need to pass this bill. We need harsher laws, because not just keeping Marylanders safe, but like I said, this is an opportunity for every drug dealer to change their behavior. Thank you.
Good evening, everybody. My name is Nick Basser. I'm a captain with the Montgomery County Police Department. I am currently the Director of Training Education for the department. Prior to my assignment now, I was Director of Special Investigations, which include our narcotic enforcement section. I have about 10 years of experience doing death investigations, including investigating, supervising, and overseeing drug-induced homicide or overdose investigations. So I don't come to this with the same level of, I cannot replicate the hurt and the emotion that the families of overdose victims have suffered. You'll hear from them much better than I could ever articulate. What I want to be able to do is kind of educate and explain a couple points when it comes to these sort of investigations, these sort of cases. First, most importantly, please do not be mistaken that drug dealers do not know what they are selling to their victims. I have seen the text message content. I've seen the interviews with suspects. They 100% know what they're dealing to the victims. In Montgomery County alone, 83% of the oxycodone tested in our drug lab is actually fentanyl. Secondly, we recognize the fact that we are not going to arrest our way out of the opiate epidemic. This is a mental health problem. It's a drug access problem, but it's also a transnational crime issue. It's also an organized crime issue. And treating this epidemic from a variety of different facets is going to be important. In Montgomery County, I'm proud to say we have one of the most robust overdose response protocols in the country. We have taught this protocol to major cities all over the United States and in Canada. We have been successful with charging individuals with possession with intent to distribute and manslaughter and overdose cases. What I can tell you is ultimately the resulting penalty for state cases is often less than 18 months in jail. In fact, we've had overdose cases that resulted in death where the defendant has got or received a penalty of probation before judgment. So for those reasons, I ask that you please support Senate Bill 1075. Thank you.
Good evening, everyone. My name is Debbie Santini, and I'm in favor of the Senate Bill 1075. I'm the mother of 2 children, and my youngest son, Jesse Bird, died 2 years ago, right here in Annapolis on February 16th, 2022. He died in Stella Recovery House on Marta Lane, 5 days after entering that house of fentanyl poisoning. He was found dead on the top bunk of a bed. His alarm went off for his work at 4:30 in the morning. Nobody called for help for him until 7:01. 2 hours and 31 minutes, if I'm correct. There was 10 people in that house when my son died. Only 4 people were interviewed by Annapolis City Police Department. in the investigation of his death. I'm in favor of this bill. My other son has lost his brother, Jesse. His dad will never be the same. My life will never be the same. Jesse was a beautiful child. He had a beautiful smile. He wanted to get his life back together. He made a list of priorities that he wanted to accomplish after going to treatment, and he wasn't given that opportunity. I believe this bill will help put drug dealers away for a period of time that will save lives. We have to start sending a message to drug dealers that says we are tired of our children dying of fentanyl, illicit fentanyl. This continues to be an attack on American citizens that is destroying families, not only in our state, but across our nation. It's leaving families devastated. I may never know the drug dealer that distributed the drug that killed my child, but I do know that if stricter laws and harsher penalties were put into place, it will save lives. Thank you.
Hello, everyone, and thank you for the opportunity to testify here today. My name is Jackie Long, and I'm from Baltimore, Maryland. And I'm here to support the SB 1075 Victoria and Scotty's Law. My son was born January 1992 on a Super Bowl Sunday. We had a party planned that day, but all of the guests that were going to be there ended up at the hospital waiting for my son to be born. We loved football together, and we celebrated a Super Bowl win with the Ravens. That is the photo that you see on this shirt today. He loved life. He loved his family. He was trying to pull everything together. He was had appointments to fighting an illness. He had appointments fighting substance use. He never got to make any of them because a dealer sold him cocaine that was laced with about 4 times the lethal amount of fentanyl, according to his toxicology report. You see, my son didn't want to die. He thought he had received that drug and had no idea it was fentanyl in there. We had plans in place, but he never got to do any of them. His chance to survive it all was taken from him. So how many families have been shattered by that same distributor of death, distributor of fentanyl-laced drugs that poisoned my son, his girlfriend, and many more? My cousins and many friends have lost their children as well. We must stand together to bring justice for all. We need to hold those who distribute fentanyl accountable for murder. It is drug-induced homicide. I'm here to be a voice for my son, for Stephanie, for hundreds of thousands who have lost loved ones due to the distribution of drugs mixed with or only is illicit fentanyl, and bring change to give our judiciary system the tools they need to take action for strict sentences, the maximum. We need this bill to pass to hold those accountable. I understand this bill was read on the February 2nd. My son would have been 32 years old. That was 32 years ago. 32 days ago. That's a sign that my son is saying we will do the right thing if we pass this bill. Thank you for your time.
All right, thank you all very much. Questions from the committee? All right, Tina, I just want to say thank you all. I know you waited a long time to testify today, and I know you were sharing some of the most painful moments of your lives, and just want to say thank you for sharing your stories and taking the time out of your day to do that and come up to Annapolis to testify and to advocate on behalf of your loved ones and for countless Marylanders. So just want to say thank you for that. Thank you. Thanks.
Thank you.
Excellent.
Good evening. I'd like to be saying good afternoon, but good evening. My name is Lieutenant Peter Davidoff. I'm Deputy Director of the Special Investigations Divisions at the Montgomery County Police Department. I'm also here as a father who lost his stepson to fentanyl poisoning less than a year ago. Beginning in 2016, we've seen changes in the drug culture and the increasing prevalence of fentanyl and illegally sold drugs nationwide. This has resulted in vast increases in overdoses compared to 2015 when fentanyl wasn't prevalent. We are seeing overdoses, including fatal overdoses, all too frequently. People from all walks of life are falling prey to addiction and death. Current legislation was not designed to address this level of damage to our community. Particularly disturbing is the increase in youth overdoses. Montgomery County Police defines youth overdoses as those under 21. In 2015, we had a total of 3 youth overdoses in Montgomery County with only 1 fatal. By 2022, that had risen to 48 with 11 fatal overdoses. And in 2023, we had 97 youth overdoses, including 11 fatal. That's a 102% increase in just 1 year. Fentanyl has taken over the illicit pill market. It is shaped to look like prescription opioids such as Percocet or other legitimate prescription drugs, and is indistinguishable from legitimate pharmaceuticals. It's also being found in other street drugs such as cannabis and cocaine. Data from the DEA indicates that 2 of every 5 fentanyl pills contains a potentially lethal dose. By 2022, fentanyl measured by units of dose represented 78.9% of the seizures in the Haida region encompassing Maryland. Investigations show that dealers know they are selling fentanyl to users who unbelievably are actively seeking fentanyl to get high. Community education efforts and the introduction of Narcan have saved some lives, but they cannot by themselves stem this time. Lastly, it's important to note that our fatal overdose victims often travel to source areas to obtain fentanyl that ultimately kills them. Unfortunately, current laws do not allow the prosecution of the drug dealer in the jurisdiction where the death ultimately occurs. This bill will allow for such prosecution. Individuals who purvey fentanyl face stiffer penalties for drug distribution than they do for their products taking someone's life. This legislation will allow for penalties appropriate to the crime and allow for the prosecution of multiple levels of dealers when they sell a product that causes injury and death. Please give us the tools that we in law enforcement need to deter this behavior and hold those who make life so cheap accountable. For these reasons, the Montgomery County Police Department requests for favorable report on SB 1075. Thank you.
Excellent. Thank you very much. No questions. Have I missed anyone that wants to testify in favor of this bill? All right, so with that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Is Ann Seacott here? I don't see. No, they're not. No one's virtual. Thank you. Thanks. And then Dan Rabbit and Jesse Dunleavy. Nope, there you are.
Thank you, Mr. Chairman, members of the committee. I'm Ann Seacott, testifying today on behalf of the Maryland chapter of the National Council on Alcoholism and Drug Dependence in opposition to the bill. On behalf of myself and my client, I want to make sure that we express condolences to the families behind me for their tragic losses. It happens every day, and it's just awful. And there are things that we need to be doing. NCADD Maryland works every day with families like that to try to find policies that are going to help. This committee has done some of those things. The General Assembly has done some of those things in the past. You've created the Good Samaritan law to help encourage people to not run, but call 911. You've helped create jail diversion programs. You've created access to medication in jails. And one time you even passed paraphernalia decriminalization, and we'd love for you to do it again. We appreciate that the bill does try to mitigate impact on people who are using drugs by adding in the piece about distribution and Good Samaritan. But we believe there is just so much more we can do other than increasing penalties. We believe that we can do things like continue to expand treatment and access to treatment, create overdose prevention sites that are proven to save lives, and do other kinds of increases for services like crisis intervention, outreach, and peer support. We believe the war on drugs has a very long history of failure. And we think that doing more of that is not the best way to spend our resources. We believe there are more proactive things that we can do to help people. So thank you.
Good evening, Chair, members of the committee. My name is Dan Rabbit. I'm the Policy Director for Behavioral Health System Baltimore. BHSB is the local behavioral health authority in Baltimore City. We oversee the full range of mental health and substance use services in the city and are really on the front lines of the opioid overdose epidemic. Again, let me as well share my condolences to everyone who's spoken before. Those are tragic, heartbreaking stories. I too have lost loved ones to fatal overdose. And I want to do everything we possibly can to prevent fatal overdose. But this bill is not going to help us prevent fatal overdose. The enhanced penalties will not reduce the availability of drugs. They will not change the makeup of the drug supply. We have tried to use harsh penalties to deter drug use and drug distribution in the past, and it doesn't work. What this bill will do, though, is be a counterproductive measure that will engender more fear among people who use drugs. This will reduce the likelihood that people will report overdose, reduce the likelihood that people will participate in harm reduction services, make people less willing to come out of the shadows, and build trust with caring providers who can help them engage in treatment and get on the road to recovery. We appreciate the protections in the bill, but we think that this chilling effect will still be there. If people who use drugs hear about people being penalized in these harsh ways, it will discourage people from coming out and reporting overdose. We need evidence-based approaches to prevent fatal overdose that reduce the harms associated with drug use. This bill is not it, and we request a unfavorable report.
Hi, thank you, Judicial Proceedings Committee, for letting me speak. I'm Jessie Dunleavy, a lifelong Marylander. I have a master's degree in library and information science and spent 40 years as an educator. Since my son's fatal fentanyl overdose in 2017, I've devoted my whole life to drug policy research. I serve on committees, both locally and around the country. I attend national conferences and have connected with national thought leaders who have restored my faith in what's possible. I share all I've learned in every way I can: opinion pieces, a blog, interviews, presentations, and I wrote a book. I stand with these families who are brave enough to tell their stories and who fight for policies to spare others their fate. My hat goes off to you. My heart is with you. Your cause is noble. For your unspeakable loss and for your commitment to public safety. Yet public health experts and addiction researchers warn that without sufficient evidence, blanket minimum sentences will not reduce overdose or deter drug distribution and will consume scarce criminal justice resources and worsen racial disparities. The United Nations, the American Medical Association, the Cato Institute, the National Academies of Sciences, Engineering, and Medicine, the Rand Corporation, to name a few, also agree with the following facts. Because illicit fentanyl is infiltrating so much of our drug supply, both sellers and users are often unaware of the contaminants, meaning that drug-related deaths can easily be the result of ignorance rather than malice. Also, secondly, going after people at the lowest level of the supply chain, leaving the original suppliers and the kingpins untouched, will result in longer sentences for mostly low-level dealers, particularly people of color who may be selling to support their addictions. For these reasons, I am praying that Maryland resists implementing this law. We all want the same thing, but this isn't the way to get there. Thank you very much.
Thank you very much, Ms. Dunleavy. Appreciate the testimony and thank you for continuing in the fight. So thank you for being here with us. Questions from the committee? All right, seeing none, thank you all very much. And with that, I believe that'll conclude the testimony for Senate Bill 1075 and the hearing for Senate Bill 1075 and our hearings for the day. Have a good evening, everyone.